Hi everybody. We're just sitting over at Jeff's, currently waiting for the for a natural break, basically, to be able to move over. In the meantime, what I'm going to do is, if you guys aren't wanting to watch over there, I'll put on one of the Zoom Corp videos here, so that there's something for you guys to be entertained to, shall I? Oh, actually, you know what? I might as well just put the cord on. That way you guys can hear exactly from where I am. Okay, hang on. Can I pin the link tree? Yes, I can pin the link tree. Hang on, give me a second. YouTube. Why is it showing... YouTube's showing all kinds of suggested videos to me now, but it's not the ones that I actually want, which is strange. My channel... My video, which is showing my big old face. And link tree, link tree, link tree, link tree. Can I just say, you guys are very patient, and I very much appreciate it, guys. Pinned. Okay. Now, put that up there. No, that's not going to work there. Alright. Okay, we'll go with these guys. Live stream, present, share tab. Okay. Stream start, Jeff stream. Actually, that might work better. Give me a second. Watching both streams because the boom is adorable. Fair enough.
I have no further questions subject to redirect.
All right, there we go.
Assistant Chief Zellman, does the burn permit an individual to burn a bleach bottle or any container of bleach in their burn site?
No, sir, that would be not permissible.
Okay, and what about clothes that have metal buttons on them? Would that be a permitted item to burn in any burn site that these permits involve?
No, sir.
What about steel-toed boots? Are those legal to burn in these burn pits?
No, sir.
And what about underwear and socks? Are those items legal to burn?
No, sir.
Okay, so those are not covered by the burn pit that you've been.
I will
shown
send him
as
to jail for the rest of his life. He burns some socks.
I have nothing else, Judge.
There were metal buttons in the fire. He's guilty of murder.
Seeing people's burn pits and what they throw in it if you have to put it out, is it common that in areas such as Mequon, people will burn some of their trash?
If they are doing so, it's in violation. I have gone
Oh,
to
yeah.
reports
Chess
of
isn't common.
items being improperly burned. Yes. So I have seen other people improperly burn items in the city of Mequon.
No further questions.
Do you recall the date of this incident? In other words, the time period of around May 19th, 2020, May 20th, 2020?
Are you asking about the
Do you
time I was on?
recall, you recall going to this scene?
Yes.
Okay, I mean,
Yes.
you have your own independent memory.
Yes.
Okay. Had there been heavy rains the days before that?
Yes.
And you found that there was still a fire that required some intervention by you to allow people to go through it. Is that correct?
That is correct.
Even though it had been a heavy rainstorm?
Correct.
Nothing else?
I don't have anything else for Deputy Chief Zellman.
You may
Thank
step
you.
down, sir.
Okay.
Yeah, with burn permits, we do have those over here in Sweden as well. And of course, I would never do it, but I have heard on occasions that trash will be burnt as well.
As far as it relates,
Two
to the
stipulations.
Kansas case.
Because there was 2 witnesses that couldn't show up today.
Thank you.
One
The
was
first
a was a,
I will read as marked
pro-
as defense
was a
exhibit
prosecution witness that was being
361,
was being
that
recalled
the
for a
both
prior
sides
inconsistent
parties
statement, but
stipulate on May
mysteriously suddenly
26,
went out of state.
2020, Officer Kyle Morrissey of the Kenosha Police Department obtained video footage from Casey's General Store, 280 Highland Drive, Fredonia, Wisconsin, and Ozaki High School, 401 Highland Drive, Fredonia, Wisconsin. The video footage was later reviewed and nothing of evidentiary value was located. This is signed by Attorney Michael Gravely and myself, dated today. We'd ask that Defense Exhibit 361 be received.
And is that agreed?
It is.
And as I indicated earlier, in the trial, several weeks ago, when something's stipulated, that's agreed by both parties as being accurate, and no further proof will be received on that subject to either bolster it or to question it. Any question about that? Okay, thank you.
The defense is going to read the second stipulation, which is marked as Defense Exhibit 364. It reads, the following are statements attributed to Detective Lauren Anschutz of the Kenosha Police Department, who is an unavailable witness in this matter at this time. The parties have stipulated that these statements should be read in their entirety to the jury in place of testimony that Detective Anschutz would have made if he had been available. On May 19th, 2020, Detective Anschutz interviewed OA. During that interview, OA told him the following. Her brother was playing with Legos in the basement of her father's home because he likes it down there. She went down there to check on him. OA told Detective Anschutz that she never saw the unregistered gun and that she never saw any guns here in Wisconsin.
Yes.
In Detective Anschutz's report, he reported that during a phone conversation with OA on May 22nd, 2020, OA stated the following. Mr. Anderson never took the chainsaw out of the back of the van. In Detective Anschutz's report, he reported that on November 6th, 2020, OA stated the following. Mr. Anderson brought a chainsaw on the way up to the tree farm. When they went to the tree farm, Mr. Anderson and her uncle were fixing the chainsaw. When they left the tree farm, Mr. Anderson took a different chainsaw home. Once they arrived at the tree farm, Mr. Anderson borrowed Grandpa's work boots and took off Grandpa's boots and placed them in the van and took them home. She believed Mr. Anderson had a storage unit. Mr. Anderson told her he had to leave to go to the storage unit one day and returned 10 minutes later. That's a stipulation that's signed by Attorney Michael Gravely and myself, dated today. We'd ask that Defense Exhibit 364 be received.
Stipulated?
That is stipulated, and we have no objection to the exhibit.
All right, they'll be received and are stipulated too.
So lying under oath is bad.
Yeah, even if you're 14, still quite bad.
Yeah, I had that argument with someone over whether or not 14 was old enough to know the difference between right and wrong, and
yeah.
Defense rests.
the age of responsibility and whatnot. And
All right,
defense just
and,
rested.
Mr. Rivley?
well, there you go.
State has one witness, and that is Officer Hana.
And while he's doing this, Hayden, you said you were stream sniping me. What you can do is when you came into, if you like bounce out and then come back into chat, there should be a little pop-up thing that says stream this to your audience.
Yeah, but I think that would mean that I have to kill my current stream. I looked at that when I came in.
Ah, okay. Maybe it does. I just don't know. No one's ever used it before. All right, we've got the last little quick witness here, and then we'll be heading on over to Ozzy Overlaw'd. Yeah.
You solemnly swear the
we
testimony
go.
you're about to give in this matter with the truth, the whole truth, and nothing but the truth, so help me God.
Yes.
Please be.
God forbid we
You are.
hear something truthful in this case.
Can you please state your first and your last name and spell both your names for the record?
Eric Quintana, ERICK QUINTANA,
And Officer Quintana, where are you employed?
Kenosha County Detention Center,
And what's your position there?
Direct Supervision Officer.
And so, Officer, how long have you been employed at the detention center?
It'll be 5 years next month.
So I want to ask you about a particular area of the detention center called H West. Can you briefly describe what H West is?
Oh my
It's a
God.
secondary unit.
Does it really matter
Units
where
in
they
the
were
back,
situated
they
in
sent
there?
For discipline for X amount of days.
No.
And how many, do we call them cells in that area?
Yes,
How many cells does that unit have?
22.
22? And how are they tiered? Are they all on one level or are they on two separate levels?
1 through 10 is on the bottom, 11 through 22 is on the top.
And when an individual is in H West, and I'm speaking now about back in the time period of February of 2022. So if things have changed, please alert us to that, okay? In February of 22, what was the arrangement for an individual who was assigned to H West? So how long would they be in their cell versus in other locations?
Usually sometimes like there'll be a malfunction and we'll have to move them from a different cell. That's the only time they're moved.
Okay. And so how many hours a day are they in their actual cell?
23.
And then for that last hour then, unaccounted for by in the 24, what is happening to an inmate who is in H West?
It is their rec area. They're allowed to be in the day room where there are lines they cannot cross. They have to stay in a specific area.
And where are the officers, meaning jail staff, who would then monitor compliance with that? Where are those individuals located?
It's the officer station. We call it the bubble, and it's looking into the H West day room.
So, and I assume it has a vantage point where all of the cells are visible?
Yes,
And how many officers would be assigned to monitor H West at any given time?
2 officers.
2 officers? And are they both located in what you call the bubble typically?
Yeah.
All right. So I'm going to ask you to just orient me through a couple of pictures. And first of all, was a request made that you take a couple of pictures from the vantage point of particular cells? Was that what you were asked to do?
Yes, my supervisor instructed me to take 2 pictures from each vantage point.
Okay. And what did you utilize? What piece of machinery or equipment did you use to be able to take those pictures?
We have a body camera right here, and we're allowed to take pictures.
You're being asked to speak into the microphone a little more directly. You have a soft voice, and this is a hard room to hear. Okay, so if you could speak up. So again, answer my question.
We have a body cam,
Okay.
and it allows us to take pictures when we change the options.
And did you do that upon our request?
Yes,
Okay. So I'm first going to have put up on the display up there what's been marked as State's Exhibit. Is it 362?
362.
362, officer. My first question is, did you take this picture once you see it?
yes.
Did you take that picture?
Yes,
Okay, so what cell are you directly in front of and facing out from when you took this picture?
to my back is H West 9, and I'm looking at the H West 20.
So if a person was assigned in H West 9, this would be what they looked out and saw from the very front of their cell?
Yes,
Okay. And is this picture, which is 362, Is that a true and accurate copy of the vantage point from cell 9?
Yes.
Is there any changes or alterations from what you know to be the vantage point from cell 9 that in this picture, other than the sticker being on there? Otherwise, is it a true and accurate copy of what you see when you look out of 9 today and back in February of 2022?
That is what you would see. That's what I would see, but the inmate would be behind the mesh.
So his visibility would be even more compromised?
Yes.
Okay. But if you're right at the doorway and out of the doorway, this is what you see?
Yes.
Judge, I move admission of Exhibit 362 based on the testimony thus far.
No.
So from this picture, are you able to orient us as to where cell number 20 is?
Cell 20 would be right over here.
Okay, so it's on the separate tier, correct?
Yes.
And it is that essentially as far across as this particular dorm or jail area takes you? It's on the far other end?
Yeah, it's the opposite side.
Okay. And it's upstairs at that location, is that right?
Yes.
So for 23 hours a day, an individual in cell 9 would only see the individual in 20 in the vantage point you've just shown me. Is that correct?
Yes.
Okay. So what if a person was moved to cell 11? Is 11 visible in this picture? And if it's not, then just please tell me.
It is not visible.
Is 11 the neighboring cell to 9, so it would be right next to it?
No, it would be above.
Okay, so 11 is, I see like a ceiling on this. You see what I'm talking about?
Yes.
Okay, is it above the ceiling?
Yeah.
Is it directly above 9, or is it directly above the neighboring one, which I assume would be 10?
It would be the neighboring one above.
Okay, so it's directly above the neighboring cell.
Yes.
All right, and then if one was in 22, where is that located?
22 is going to be way at the end, right about there.
So that would even be slightly farther than 20?
Yes.
What would be the distance between cell 9 and cell 20 during those 23 hours a day? How far away would you estimate those two are in distance?
I would say approximately 50 to 60 feet.
50 to 60 feet. Okay. And is this a area of the detention center that you have worked in often in your career?
Yes.
Describe the ability of someone from 9 to communicate to 20 or 22. What tone of voice would you have to use in a normal situation to be able to get the people in 20 and 22 to be able to have a conversation with you?
You have to talk pretty loud. Basically, you'd be yelling because there's on opposite sides of the room and there's a lot of echo.
And what, if anything, can you say about whether that yelling would be something that other cells would hear? I mean, in other words, is there some kind of ability to yell in a targeted way, or would other cells also hear it if you yelled, again, from 9 to 20?
No, all the cells will be able to hear.
So if I were to simply whisper or speak in a very conversational voice, I had something confidential I wanted to say from 9. Based on your experience in this area, would 20 or 22 be able to hear me?
On a whisper, no. You just have to talk a little bit louder than normal just for them to hear you from 20 to 22.
Okay. From 9 to 20 or 22?
Oh, you'd have to talk loud.
Okay.
You're not going to whisper that.
Okay. So only if 20 and 22, which are close by cells, correct? Correct?
Yes. Correct.
Okay. In this, there is, it looks like there's a red line. You see the line I'm talking about?
Yeah.
Can you just point out where that red line is for the jury? So just draw where that red line is so that they know what we're talking about. And does it go on both sides of the stairway there, that as depicted in this picture?
Yeah, it cuts off the stairs, and it cuts off part of the day room on the other side.
Okay. And what does that red line mean in the context of the rules or life in H West?
When you're on discipline, you're not allowed to cross those red lines for any reason.
And are people on discipline? Is that, if you're on H West, are you on discipline automatically?
Yes, most of the time.
Okay. So are there ever times when a person who's housed in H West can go closer to that than that red line in the 1 hour a day that they're out?
The closest you'd be able to get without crossing it would be here and here.
Okay. And that's only for 1 hour a day at maximum?
Yes.
Now, if you're in the upstairs tier, are you allowed to walk into the downstairs tier during your 1 hour?
Yes, everyone's allowed to walk in that red area.
And if you cross that red line, then what happens?
One of two things. One, you get a warning. If you do it again, your recreation's over, or you can just tell them it's over right then and there.
And does that come from the two people up in the bubble?
Comes from one or the other.
Okay. And is this something that you believe is regularly and consistently enforced?
I enforce it, yes.
Okay. I'm going to show you now what's been marked as State's Exhibit 363. And just let me know what this is in relation to this case. So what is Exhibit 363? First of all, is this a picture you took?
Yes.
Is it, again, a true and accurate vantage point from the place you were situated when you took this picture?
Yes.
Does it accurately reflect the distances from one end of this cell block to the other and where the cells are that are in question in this case?
Yes, it is accurate.
Do you think it's changed or altered in any way other than the sticker that's on there?
No.
Again, I move admission of 363 based on the testimony, Your Honor.
No.
So from 363, what is our vantage point?
I'm standing in front of H West 20, looking at H West 9.
I think we lost you in the microphone. So
Oh.
one more time.
I'm standing in front of H West 20, looking at H West 9.
So where is H West 9 on this photo? So the jury knows where a person who's in 9 is located.
Right about here.
Under the stairwell and on the back, towards the back wall?
Yes, in that corner.
So it's the far corner under the stairwell.
Yes.
Are there occasions where two inmates are ever out for rec time at the same time, or is that something that is forbidden?
No, that is not allowed.
Okay. Well, riveting testimony here.
Where is 22 on this? If you can see it, where's 22 on this particular exhibit?
You won't be able to see it. It's two cells this way, like to the left.
And the red line that we're depicting here, is that same? Same red line we saw in the other picture,
Yes, it is the same red line.
just a different vantage point.
Yes.
Okay. I have no further questions.
Thank you, Judge. I'm going to keep 363 up. The state had asked you that this is the vantage point from cell 20, correct?
Yes,
And again, that's from outside the cell, not inside,
correct.
because of view from inside would be obstructed.
Yes.
So if the state had asked you about the noise and stuff like that, and you're familiar with working in H block, right?
Yes, I'm familiar.
And it can get you said echoey.
Yes,
And so if someone says something and it is not a whisper, chances are other people in the unit are going to be able to hear it.
yes, correct.
And so if you're in a cell and you hear something coming from a different cell, it might be difficult to pinpoint exactly what cell it's coming from.
Yes, correct.
It's only potentially that you can know who it's coming from based on your experience by sound of the voice, if they're saying who it is, those type of identifying factors.
Yes.
And so coming here then from the picture we see, can you see cell 11 in this picture?
Yes, I can see cell 11.
And can you point out to the jury where cell 11 is?
Right.
Okay, and then where is cell 9?
I would- right.
So these are relatively close to each other, just on opposite tiers.
Yes,
So before the state had asked you that if you're whispering or talking quieter from cell 9, would it be difficult to hear in cell 20? You gave an answer. But as far as with cell 11 and cell 9, individuals would be able to speak quieter and maybe be heard just by those cells.
you'd have to talk a little louder, not as loud as 9 and 20, but you still have to talk fairly loud because they're on opposite tiers.
Mhm.
But not, you don't need to yell.
Correct.
How often did you work in H West?
I was pretty often on it on night shift when I used to work it.
A night shift?
Yeah.
Okay. And the state had asked you about the rules about rec and staying inside the red lines. There are times where individuals housed in H West do go outside those lines.
Yes,
And some deputies and correctional officers, some of them might not say anything.
some give them a warning.
A warning, but they're not gonna, some don't enforce it as heavy as others, correct?
Yes,
That'd be a fair sentiment.
yes,
So there are times where other inmates do go up to the cell doors of the others
yes,
and they talk to one another.
yes,
And this would be during the rec time?
yes, it would be during rec time.
Okay. When people get transferred in H West, do you have to update the records?
Yes, we do.
And so if someone gets switched in between shifts, it would be the next individual that has to update the change?
No, it's the officer who made the switch updates it.
Okay, and do you update that immediately or at the end of your shift?
I update it immediately.
Okay. And you also had talked about how you had a request made to take these photographs.
Yes,
When did you receive that request?
it was on Thursday before my weekend off. Supervisor called and then instructed me to take pictures, and I did with my body cam.
Okay, just this last Thursday.
Yes.
Nothing further.
Questions?
Okay.
So during rec time, is a person who is residing on the first floor
Oh, shut up, Gravely.
able to go onto the second tier ever?
No, they're not allowed to do that.
So that's never permitted.
No.
And if, and did I hear you correctly that based on the mesh and the obstruction and the echoes and so forth, that you believe that it is.
So is someone on the
difficult
second
to
floor
tell
allowed to
which
come down
cell
into the
is communicating
commons?
With another cell, in other words.
Oh, he
if
didn't
you're in a
ask that
cell, you might
question,
not
did
know
he?
which other cell is talking to you?
Yes.
Nothing else.
I have nothing further, Judge.
You may sit down, sir.
Your Honor, the state has no further rebuttal at this time.
The defense has no rebuttal witnesses, Judge.
Right. Let's take a break at this time, and I'm going to ask that you return at 2 o'clock.
Wow.
Please don't discuss the case with anyone, not even another juror. Rewatch your lesson when you come to the trial. Any questions? Thank you.
Wow. We're done, it looks like. Huh.
Well, there we go.
Well, let me quickly burn through these super chats here, and then we'll figure out what's going on. Elise Lane says, if he was to testify, can they still ask for a Mr. We already read that one. You got kind of like 1.5 there. With 2 witnesses before lunch, it doesn't seem like he's testifying. It does not seem that way now, does it? DA would spend 4 days on him. D, what says Jeff simping over Winona? What are you talking about, D? What? I have no idea what that's talking about. Russell, why do you think defense counsel did not bring in someone to testify about minute blood found in the defendant's van? Because I thought they just trashed them. I thought they did a pretty good job of destroying them on their cross-examination. I don't think it was necessary.
I could have done a much better job than I did. And it's important enough that I think it needs to be recovered so that you understand your options are that you can testify in the case if you want to. If you decide to testify, then the district attorney would be allowed to cross-examine you, question you about anything which is pertinent to the case, which could involve matters for which you are not on trial, and you'd have to answer those questions. He would also be allowed to question you about any matter, recent event, which would be suggestive of dishonest behavior, and you'd have to answer those questions, even though they don't directly relate to what is on for trial here. And he could question you about criminal history, and he'd be limited to asking you if you've been convicted of crime before and how many times. If you correctly answer those questions, that would be the end of it. If you did not correctly answer those questions, then he would be allowed to go through and identify specific crimes, dates, and places of conviction. Any question about any of that?
No.
Okay. If you decide you do not wish to testify, then there'll be no cross-examination. You won't be questioned about anything about this case. And you would have the option for me to instruct the jury that your silence must not be considered in any way. Defendant in a criminal case has an absolute constitutional right not to testify, and his silence must not be considered as evidence against him in any way, or be considered in any way by the jury in deliberating on their verdict. Do you understand that?
Yes.
I would give that instruction only if you requested it. If you did not request that instruction, then I would not mention anything about your decision not to testify in the case. You understand that?
Yes.
The district attorney would not be allowed to comment at all upon your silence if you decided you did not wish to testify. Do you understand that?
Yes.
Any questions about this at all?
No,
Have you had enough time to discuss this matter with your lawyers?
I believe so.
Here we go. Last
Have
chance.
any questions that you have been answered to the best of their ability and your satisfaction?
I believe so.
Okay. Any question anybody wants further asked?
Judge, I would just say that we, as a team, have talked to Mr. Anderson about all the pros and cons, just like the court laid out, and so his decision is fully informed and knowing that it's held.
Okay. Anything that you had to comment?
No.
Okay. Then what's the plan when the jury returns?
So will the judge want to have a short instruction conference with us?
I propose, I hope,
So he's not going to testify.
to
Good.
send you electronically proposed instruction draft number 1. I hope so. I hope you have within about a half an hour, so you have some time to review it, and then we will discuss it when the jury when we return. Given what you've already sent me, I don't think it'll be too lengthy. And anything else?
Well, I think that the parties just want to know what the court is contemplating for this afternoon. And so is the court hoping to instruct but have us argue first thing in the morning, or is the court still hoping to argue this afternoon? What is the court's preference?
I think it.
We'd be back.
I think it's unrealistic to try to complete everything today, and I don't want to break the arguments up. So, yes, I will instruct this afternoon, and then we'll start with argument in the morning.
Yeah, that's fine with the state.
And I won't put a time limit on you, other than when I was a
Wow.
young man, I used to. We lived across the street from Kenneth Grube, who was an eminent federal judge in Milwaukee for many, many years. And I would shovel his snow.
Judge,
And,
the
the only
fuck?
advice he ever gave me,
What the hell was
even
he
though he
doing?
knew I was in
Just
law
going off on a
school,
random tangent?
was I think he probably said stick to shoveling the snow, but he said the brain cannot absorb what the seat cannot endure. So I think that was wonderful advice from him, and I'll repeat it to you. So,
And Judge,
and I do need to leave here at high noon tomorrow.
Yep. Understood.
I need tomorrow, that's fine.
Allowed.
And then, just because you're going to be drafting up those jury instructions, the defense would be seeking instruction 315,
Yes, okay,
just so you know to include that.
sure. Yeah, you should have them within,
Do you want us back here physically at 2 as well?
at 2:00, yes, be back. And I did not ultimately, I didn't want to give 2 separate instructions on counts 1 and 2,
Okay,
but
so give the more verbose one for both of them?
I am giving the standard, but I'm going to omit the paragraphs you've deleted from both.
Okay, perfect.
Will you bring the card?
You were able to open up the documents, that's correct? You were able to open up the documents?
Yes, thank you.
Just
Yes,
wanted to make sure.
yes, thank you very much.
All righty then.
So what now?
Wow. Well, first thing is to clear off these last 4 super chats, and then wrap it up and head us over to Aussie land for jury instructions. Wow, that was surprising.
Kind of anticlimactic, I think.
All right, let me just burn through these here real quick. Nicola Maxwell, Zach Bone Steel, love his voice, not guilty. As nice a voice as he has, that's not how we're deciding guilt or not guilt by the sound of their voice. There's Lon Cuck has a page for people like you. Just kidding. Van Ray lol. Nice to know that the jail looks like my U.S. high school. And official Rogant. So we just gonna let the DA off the hook? Yeah, probably. And there's a couple other that they're just too far back for me to scroll back to and highlight. But Mangs, thank you so much for your $10 super chat. So was Gravely just trying to prove Snitch 2 was lying due to location? I've heard inmates can communicate by draining toilet water and sending notes through the drain.
Which I'm not sure what the
Ish.
fuck we're gonna do, to be honest.
Yeah, that's there is that. And I think that is it for the super chats. All right. Phew. Are you ready for the handoff, Ozzy?
Yeah, that's fine. I'll head across and I'll see you all soon. And there we go. Inception, what's happening? Oh my god, thank you to everyone that stuck around and that has been watching on the stream snipe. State should be limited to one sentence. We have proven nothing of note in the disappearance of the alleged victim, and as such the state withdraws its case. Apologies for wasting the court's time. We formally apply for our own sanctions. Oh, Christ. So, jury instructions this afternoon. Everyone back at 2 o'clock, so I'm a little bit confused as to why he wants everyone back then. But, Kaiser, there's a good chance there may not actually be a tomorrow. Actually, you know, I'm going to move this across here because I keep looking off to the side instead of at you guys. Should not take the jury too long to come back not guilty. I would expect not at this point. I mean, I'm thinking if it's going to be today, few hours at the max, because then we'll have because you know when you're on jury duty, you kind of want to you want to put on a little bit of a show, make it not look like it's oh, tomorrow's closings, is it? Damn it, I wasn't. Like I said, I couldn't hear shit. I had Jeff there, Jeff there, Jeff there. Okay, so closings are tomorrow. Well, there you go. Okay, so that means we've got jury instructions at least until... Okay. We'll see. Well, I guess maybe we'll go back and watch the XXX verdict. Good news for everyone. I double-checked with Nick. We're officially going to be doing the Rittenhouse using his streaming, which I was very much appreciative of him for. Thank you very much, Nick, if you ever see this, although I highly doubt it. Like the optimism, just not sure the jury's going to see through the bullshit, given how Lauren Cuck's chat's been. Yeah, look, that's not going to be... That's a problem, unfortunately. When you take the lowest common denominator, all of a sudden, anything can happen. And that's just it. Juries are always a wild card. That's why in certain instances I prefer a judge-alone trial, particularly where it's detail-orientated, like finance matters. But... everything Olivia, Sadie, and Munch testified to has been impeached. The jury has to see it as we do, not guilty. Should bloody well hope so. Can't watch Rittenhouse again. Wasted weeks of my life on that the first time around. Fair enough. Jeff was taking too long. I just bounced over. No worries. Alright. Just got back. Phone died. What happened before the end of the break? Not a lot, really. They brought on some guy from the prison, I think, because I was barely able to hear it. How was Lauren Crump spinning the trial? Honestly, I don't know. It's really weird. It's like mob mentality, because it's not even as if Lauren Crime have any sort of, like, commentator or anything giving commentary during the actual trial. It's like it takes one specific wine mum to say something, and then it sort of... people can't start echoing, and it just sort of spirals, which is really concerning given that, you know, these people have... is anyone covering the morning of the trial on Rumble? I don't think Jeff streamed it to Rumble, so unfortunately not. Zimmet, if you want to watch the morning, you'll probably have to go and watch Jeff's stream. Although, I'm not sure that there was much to it, to be honest. I'm going to bet that DA Grave Robber will cross the line in closing about the defendant's silence. He will try to be sneaky and say something like he never said this or that. Yeah, look, Jim, I'm not going to disagree with you. He's probably going to try and pull some sort of shit. So, yes, by all means, please remember to hit the like, subscribe, and press the bell. Also, guys, might as well take the opportunity, given that I'm filling them out now. At some point, I am actually going to start up a secondary channel, Wizard of Oz, and it's going to be more like gaming and nerdy stuff and that sort of thing, to not impose on the regular people that don't really enjoy that stuff. But I am starting to put together card packs that you can't really see there. All of which are going to be either given away. I mean, I'm putting a bunch of them together to give to a charity that sells them to raise money for kids in hospital. But I will also be giving out a few as well. So keep an eye out for that. See, the annoying thing is, what's that? Missed the guy before the CEO from prison. What did he have to offer? Dunno, Savita. Didn't see it. He's done it the entire time and Schroeder allows it. Yeah. Okay, so the raid's incoming. Fair enough. Hang on. No, that's fine. Don't need that. Don't need that. Okay. Plain Wi-Fi sucks. Sorry to hear that, Flox. The mustache sent me. Oh, good. I'm glad. Oz, not Oz. It's going to be... I haven't actually... shit. No, I did not send them links. Whoops. Of course I bounced out of there before I did that, because I'm a dick. Is a new channel where we'll be posting updates on your plans for world domination? Yeah, probably. It's the easiest way to do it there. Volume's really low compared to Jeff's. Okay, fair enough. Hang on. Alright, hopefully that's not going to blow anyone's ears out. That was just me trying to sort out the audio. You know what I'm like, guys. I try and make sure that the audio for the trial is not going to... I'm not going to blow anyone's ears out, so... welcome, Jeff.
Hi. I was so tempted just to scream into the microphone right after you said you don't want to blow anyone's ears out. I was so tempted. I was going to, but then I realized I have headphones on too.
So I didn't, because I was stream sniping that last bit, I heard shit all from that prison guy because I was hearing like everything going 3 times and it was really difficult to understand. What I gathered was that there was very little that he provided and that if anything it further impeached Munch's testimony.
Well, they'd have to shout across the facilities at each other, but then on cross-examination it was like, well, yeah, they're out of their cells sometimes. And there was people on the bottom floor aren't allowed to go up to the top, right? But they never asked the question, can people on top go down into the commons area, which of course is yes. It was pointless. The whole thing was just to bolster Munch and somehow say that, because the guy said that he was one place when he may have been in another cell means that Munch is correct and was being honest is just a ridiculous statement.
Yeah, well, I mean, that guy's about as honest as a $3 bill, so... impeach the counter snitch's testimony? Okay. Today on the Triple X trial was the first time the sound wasn't low. I did notice that. They actually got their rears in gear and actually had some half-decent audio, which is good.
At the beginning, it was all over the place.
Oh, yeah. Hopefully that's a bit better. Look, is it done for today? No, as far as I'm aware, the judge is coming back at 2 o'clock. Do we think he'll have the jury instructions written by then, or is he going to spend the afternoon arguing over them?
It'll probably be the afternoon talking. Well, I think it sounded like he said they're already done. There was just one paragraph that from the standard wording they wanted deleted, and they would delete that. So I think they might be having some discussions, and then they'll read the instructions to the jury, and they'll start the arguments tomorrow morning.
Okay, so theoretically should be a fairly short afternoon then.
And tomorrow, the Mrs. Judge has a medical appointment at 12:45. So they're going to take a 2-hour lunch break tomorrow at 12:45 local, which is what, 1:45 Eastern.
Okay. All right. So basically make sure we got 2 hours of content to fill the gap, I suppose.
Yeah.
Interesting. Okay. Well, that's all right, because we have plenty of Zoom court, we have plenty of sovereign citizens, and we have plenty of other interesting little tidbits from the legal sphere to keep people interested. So that should praise for Mrs. Bruce. I'm sure she's fine, people. There's no way in hell she doesn't have private health insurance.
So the just by way of completing the totally irrelevant morning testimony, they had the two guys testify. Like I said, one just testified there was nothing on the drone footage, nothing in the dumpsters, including no body parts. The other guy testified, yes, these are his flip flops and or thongs, depending what you want to call them. These are his pants, and this is his shirt and his underwear. You don't have to see that, but there were no stains of interest on it. One of the witnesses was supposed to be a rebuttal. The two they read these statements for were both apparently police officers. One was supposed to testify about prior inconsistent statements, but suddenly, for some reason, he was out of state and unavailable to take the stand to be questioned about his prior inconsistent statements. His excuse was the subpoena period had lapsed, and so he didn't have to be there.
That's still pretty, that's still a pretty dick move, frankly.
Yeah.
So today was a filler episode. Unfortunately, it seems that way. Sorry, people.
Well, it got off to a really rough start because, one, they had the witness that Chandler was talking about, the landlord who was going to testify that he's behind on his rent, that they ultimately didn't let in as just on grounds of relevancy, even though the argument was, well, it shows that he owed money to people, and that the police didn't do a good job of seeing if the landlord, even checking if the landlord murdered.
So they introduced someone that was basically...
Well, judge didn't let him in.
Oh,
yeah,
okay.
Judge didn't let it in. He says their testimony is irrelevant. So that created an open space. Then one of the witnesses, they said he's just out of state. And then the other witness, so I guess it was the one that was going to testify about the gun or something, or whichever was the gun or the chainsaw, whichever one it was, had the flu and couldn't testify. And they said, so who's your next witness? And they said, well, we don't have anybody coming for the next hour and a half. And then the judge flipped out. And he's like, for cracker's sake, or whatever he said. Some weird old Bruceism. And he got pissed. And they're like, well, hey, it's just the witnesses. The witnesses aren't there. You wouldn't let one in. Two of them aren't here. So what are we going to do? So they called in the records lady from across the street in the courthouse. Her job was to say, yes, this is the prison, and this guy was in that cell, and the other dude was in the other cell, and that was it.
Right. Jacob's Proud Marjorie coming in with the $20 super chat. Hiya, Hayden and Jeff. Hello to the wonderful chat family. By the way, I dislike Gravely as much as I do my abusive narcissistic ex. Unfortunately, I can't type the words, which is too much, because Hayden might get in YouTube trouble. I appreciate your candor and discretion. Thank you very much.
Well, I'm excited. This thing just wrapped up real quick.
Why are you excited by that? It means the grift does not continue.
It means I get to talk about something else for the first time in 3 weeks, almost 4 weeks.
Fair call.
I get to sleep at night. I get to go to sleep like 3 hours before now.
That's actually a good point. I think after the state's closing, the case will seem stronger with all the evidence strung together at the same time, but defense will be able to poke good holes. Closing will be key in this trial. It's an interesting take, John. Fair enough.
The only thing I can think of is what they can convict him on is the daughter's testimony. And that's why I'm a bit pissed that this rebuttal witness went out of state, because even if they had the paper read from. Well, that was what the defense and the state agreed on.
Mhm.
You never know what she could have gotten out of him on the stand, and that would have been much more impactful.
It's very true. G'day, Chandler. Welcome to the. I'm not quite sure what to call this today.
Well, thank you for welcoming me. Hi, everybody. Nice to be here.
Yeah, conveniently out of state. Well, I mean, I suppose while we have time, might as well have a look, see, get your opinion, people, on a certain Solve-Sit traffic stop, if you wouldn't mind. If you've got time, I mean, I'm happy if Vices wants to go to sleep, but I'm vamping here, people. Let's face it. Where are we? Present share screen. Alrighty, move that off to the side. Alright. Hopefully the audio shouldn't be too bad, people.
Hi, I'm Officer Woods from Snow Police Department. The reason I stopped you is for it appears you have a fictitious license plate on the back of your vehicle. Do you know anything about that? I'm a sovereign human being.
Oh, come on.
Okay. And I'm an American national. Okay. Do you have your driver's license, insurance, and registration, please? No. What? No. Do you have any form of ID on you? No. Matthew Tucciarone is my name. Okay.
Yeah, Dizzy, I think that's what I'm going to do. I'll pull up this morning's footage from the XXX. Oh my god, come on. How difficult it is at YouTube? Seriously.
Alright. So, just so you know...
I've been pulled over a couple times already by state troopers, sheriffs, and this is recognized. Okay?
Okay, I don't agree. So,
Okay, well,
I'm going to be honest with you. That's actually a misdemeanor crime for you to display a fictitious license plate. Additionally, you not providing me with the driver's license is...
Oh, thank you very much, Rabbit, for the 5 memberships. I very much appreciate that. And I appreciate being told. Oh, for crying out loud. What the hell? It's not like I've got anything else going on.
Required under Arizona Revised Statutes 28-1595. That is also a misdemeanor crime. Additionally... Alright, go ahead and step out, please. Step out of your car, please.
Solve-Sit, you should be beaten with the rough end
Marijuana,
of
I need
pineapple.
another unit. Step it up, please.
I did not do anything wrong.
Pennsylvania versus Mims is a Supreme Court case law that says you're required to get out of that car if I ask you. If you do not, I'm going to force you to.
Hold on a second. I'm calling my lawyer.
Okay, get out of your car.
Calling my lawyer.
I don't think you have a lawyer.
Call your
otherwise
lawyer
you'd
if
be telling
you
him to
want,
get out
but
of
as
the
soon as
car.
another officer gets here, I'm going to force you out of that car if you don't get out on your own.
Hang on just a second. I'll be...
Mary, what I'm code for now, he's just not getting out of his car.
Sex crimes include growing weed and hook up with crazy ladies.
You're being detained right now. And Pennsylvania versus Mims is the United States Supreme
Am I
Court
under
case law.
arrest?
You're being detained.
Why?
Because
Why?
I told you, I'm investigating one crime. You also said you don't have a driver's license, which is another one. And if you don't provide me a form of identification when I'm investigating you for a crime, that is a third crime that I'm investigating you for.
There is no crime.
You are required by law to provide me your true full legal name if I'm investigating a crime.
Well, this car,
If you do not provide me with your true full legal name, you can be arrested for that.
Matthew Tucciarone.
Okay. Do you have a driver's license or any other form of
I am
identification?
a sovereign being. My name is Matthew Tucciarone.
Okay. Again, Arizona Revised Statutes
Hi,
28-1595
Officer Beers.
requires you to show me an ID card or
listen.
driver's license.
Please.
Get out.
No, I'm not getting out of the
Okay,
car. This is
I'm gonna
not-
give
I
you-
didn't do anything wrong.
All right.
I'm not getting out of
Matthew?
the car. I've done.
If you do not get out, I'm going to force you out. If you don't get out of your car,
What?
Matthew, look at me.
Oh, I thought you were muted there for a second.
Matthew,
Am I?
look at me. If you don't get out, I'm going to force you out. I'm going to charge you
it's
with
not if
resisting
we're
arrest
talking.
also. So get out, please. Come on.
so I'm guessing he didn't get in touch with his lawyer.
Get out.
There's no reason to
I've
act like
asked you
this.
probably 10 times to get out.
There's no reason to act like this. There's
Get out of
no
your car then.
reason.
All right.
There's no reason to act like this. There's no reason to
Get
act
out.
like this. Do not touch me.
Get out.
Do not
You mean
touch
during
me.
his
Get out of your car.
Do not touch me. Do not touch me. Please. Please do not touch me.
I have asked you 10 times to get out. Get out on your own then.
What are you doing? Please do not touch me.
Dude sounds like he's baked.
Ow! Come on. Get on the ground. No.
Sorry?
I say, sounds like he's baked. Dude, don't touch me, man.
Football said it.
Give me some
He's like 4
Funyuns.
years old.
It's
I
one of those
just hope
things where
there's
it's like,
a taser involved.
yeah, I'm really hoping for the taser. I really am.
No! 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 I didn't do anything, Officer Ramirez!
Okay, all right. Just
Please,
get on your
I
stomach.
didn't do anything! Get on your stomach.
Just
Come on,
Just
Officer
comply.
Ramirez.
Just comply.
Come on.
Just comply for now.
Just comply.
All right, just comply for now.
Just comply.
I'll give you information if you wish to file a complaint later, okay? But right now, just cooperate, Matthew, okay? Okay? Okay?
Very one,
All right, just listen. All right, I just got here, okay? But right now, the best thing you can do is just comply. All right? If you want to file a complaint, I will give you that information, all right? I promise. My superiors will overlook everything. Okay, all right. But he had to repeat himself, all right? Like I said. All right, just stand up for me, stand up, all right? Matthew, what are you
Come on. Let's go back to your
doing
car.
with the sovereign plate on? Everybody else, don't, please don't.
You are detained. You were detained from the beginning when I told you that.
Just relax, all right? I know. Just relax, okay? Right now, you're safe.
Yeah, what are you doing with a sovereign plate on?
Sovereign plate on.
Like
You
that.
didn't comply with my officer here. Okay? All right, just relax, all right? You are safe.
Go ahead and take a seat for me, all right?
Just
Look
relax.
at the officers. Like,
Okay?
why are you
Just
being a
like
dick,
this. I
dude?
just want some.
Put your feet in
please,
for me.
Officer Ramirez?
Officer Ramirez, no.
How can you be that thin and still have man boobs?
One for each titty.
Yikes.
If he takes his shirt off, he's gonna get some indecent exposure charges.
Yep. Court date. Love it. Oh, come on, you piece of...
Please just listen to my officer. Just
Put your
listen to
feet
my
inside,
officer.
please.
I want, okay? I'll get you some water, we'll make. Okay? Just comply with this, all right? We'll make you comfortable here in a minute, all right? Just relax.
Watch your leg, okay? Can you watch him?
Well, that
Percentage
ended better for him than
toast.
that ended
Yeah,
for
look,
that ended better than it could have.
It's very true. I was not expecting that to end the way that it had, but
We had one in just north of, well, just south of where I live back in Utah that ended much differently than that a week ago.
oh, I don't doubt it. But I now have proof that this is permeating and infiltrating Australia, which I'm not happy about.
Soft sets, yeah, right.
Yeah. So
Okay, that's not what I want to do. Never mind.
yeah, this I don't know why it looks like they've done it in the friggin' TikTok format, but yeah.
Infringement notice in the mail for failing to wear a seatbelt, okay?
Do your best.
Okay, do you...
I don't consent to any of this.
Yep, so what are your details, if that's right? Just your name and date of birth.
What do I have to give that to you for?
Yep,
Am I under obligation to give you that license?
Yep, so you're provided to give me
By
your
law?
name and address.
By law?
Name and address, yes.
Can you cite that law for me, please?
Yep, so it's the Summary Offences Act, which is 458.
Act, it's not a law. So do you agree you agree I'm a man?
I don't know, I'm not going to assume your gender, sir.
I think you can tell. A man, as in mankind.
I can't assume your gender. I can't assume your gender. I apologise.
You're right.
Yeah, I can't do that.
Yeah, I'm an 80-year-old lady. Do you agree I'm a man?
I don't know what you identify
A
as.
living man. I'm alive. Am I
agree
alive?
that you're alive, yes.
Am I alive?
Yeah,
Okay.
I fully agree that you're alive.
Okay.
Yeah.
So living man is
You're
in
present-
mankind.
You're present in body and mind.
Yeah. So
Yeah,
you
I fully agree.
haven't stipulated to me that law where I have to give you my license.
Yeah,
Show you my
so it's the
license.
Summary Offences Act. Your mobile phone is there. You're more than welcome to look up the Summary Offences Act. Go for it.
Act is not
wait
law.
here. You're receiving infringement notice in the mail for failing to wear a seatbelt, okay?
Why do I cannot understand how these guys actually think that statute law is not law.
Because it says act and not law, which is just the dumbest thing I've ever heard of.
Yeah, it's just... okay, so this is the one in Utah. I think we actually played this, but more than
So
happy to-
you have a fraudulent passport?
No.
Wonderful. That's what I'm hearing. Okay, step out of the car for me.
No.
Sir, step out of the vehicle
No.
right now.
I am not required to.
Step out of the vehicle
sometimes,
right now.
Patricia. Only sometimes.
Step out of the car right now. Step out of the car. We're going to break the window and pull you out. Step out of the car. Gun.
A self-proclaimed sovereign citizen.
Oh, well, they cut
shot
it
and
off
killed
there.
during a
It went
traffic-
bang,
Oh,
bang,
yeah,
bang,
no.
bang, 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 bang after that.
Yeah, they unloaded into the guy.
No, they more than unloaded him into the guy. 4 guys unloaded into the guy, and one of them reloaded.
So did he survive that, Jeff?
No.
That's my question.
No, he's gone.
No. He is very
And I'm pretty
dead.
sure, from memory, this guy's mum showed up in court and called 911 on the judge.
Uh-huh.
Mm.
Okay.
This
That
this
makes
was like
sense.
9 days ago.
God.
Please explain Oz versus US map, aka Vic, New South Wales, Perth, NW?
New Wales? New South Wales and just New Wales? Northwest Territories?
Well, someone asked me yesterday, is New South Wales old enough where it's just South Wales now? And I'm just like, well, okay, is New York just York now?
Yeah, I don't think that's how that works. New Mexico
Yeah.
is also Mexico, apparently.
Oh, Christ.
Seriously.
Okay.
Don't pull guns on cops. That's the moral of the story here. It doesn't matter if you're a sovereign citizen or whatever citizen. It's not a good idea to have a weapon drawn when police are interacting with you.
Holy shit. Group claims sovereign citizenship after military-grade explosives discovered. Yeah, I'm watching that.
Hmm.
Huh. Yeah, this is one of the bang, 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 bang part of the video. That was pretty brutal. Anyway, yeah.
Wait, what?
No, the video that I sent you, I assumed that would be the full video because it was on Law and Crime, but it wasn't.
Oh, yeah, no, they take out shit that just doesn't... Yeah.
For a vehicle code violation with the people inside the car.
Oh, wait, wait.
What's
This is
Caitlyn Jenner
Crypto-
doing giving news?
Well, see, I thought this was the Crypt Keeper's girlfriend. I mean, what?
What's Caitlyn Jenner?
Okay.
Saying that they were sovereign citizens. Now, that's not what got them arrested. It was actually the weapons and the military grade ammunition that was found in the vehicle, and supposedly also in what investigators describe as a sovereign citizen compound out near 29 Palms. And it's something, movement we've been following for a while. Watch.
So called.
I do not consent. Confrontations
My
with law enforcement.
favorite, I do not consent.
People declaring themselves part of the sovereign movement, questioning authority and the right of police to stop them for any reason.
And it is not a crime for me to travel without a license.
But San Bernardino County sheriffs say self-described sovereign citizens were involved in much more than the vehicle violation they were originally stopped for. 46-year-old Jeffrey Russell, 50-year-old David Russell, and 54-year-old Venus Mooney were arrested when deputies say they located explosives in their vehicle and at their Johnson Valley compound.
As much as I need to.
Fox 11 has followed the sovereign movement, which has been in the news lately. For example, the suspect arrested on suspicion of starting the 2018 Holy Fire in Riverside, Forrest Gordon Clark, repeatedly refused to leave his cell, supposedly claiming U.S. laws did not apply to him.
I remember
I do not need a license or identification at any time. This is America, right? Well, I'm going to place you under arrest. No, you need to read that before you violate my law.
That's Trent Goodbody, one of the most recognizable figures in the movement, when he spoke to us some years back as he traveled with a license plate reading private and recorded every interaction with law enforcement.
I think that there's been a major awakening in consciousness, and I can't explain why. I just feel like people are finally coming out of their fog.
That was 2017. Today, Goodbody has this to say.
I spent years in this movement trying to get more free, And
From
really
age
now I
11,
just
6
find
years.
myself out here in the middle of the desert. I've recently decided I actually went and got my license because I want to finance a car, you know? And there's certain
It's
things
so much
that
easier,
we can't
isn't it, bro?
avoid.
He sees the angry defiance being posted by self-described sovereign citizens as counterproductive.
There are some principles in what you're doing. But if you're going to come at anybody with negativity or a lower vibration or aggression, that's what you're going to get
vibration.
That's a good question.
Government
I cannot
is
remember
our
off the top of my head. Chat,
servants.
can anyone help out
If
on
we
that?
can approach the situation from a honorable standpoint and not from a place of fear or anger, we'll get a lot further.
Perhaps a gentler and kinder approach. Regardless, though, investigators say that these 3 suspects they just arrested here will remain jailed without bail. And the investigation continues. Live in San Bernardino.
Oh, there you go. Actually, if the
Wow.
Uh,
I had no idea
gonna
that
be-
was happening. That's kind of like, that's close enough to me.
Yeah.
Hello, Brandon. Would you sit on this guy's lap and beg him for presents if he put on a red suit, went to a shopping mall, and offered you small treats? For starters, never take the treats from Santa. Just don't do it. That's. Don't look into her eyes. Shit. Where's the one where they break the window? It's got to be this one.
Like that's like every sovereign citizen video. Come on. If they're not, are they really sovereign citizens if there's not broken glass and tasers deployed?
This is true.
Real
On
ID,
that
I'll show you
note,
there. Real.
I'm going to escape here. I'm gonna take off and go to bed.
Fair
Oh,
enough.
we'll miss
can
you.
get some sleep.
Sleep well.
And if for somehow something goes crazy, don't call me. I'm going to be sleeping.
Fickle.
We'll see you for arguments tomorrow.
All right.
Bye,
Everybody go
folks.
subscribe to Jeff's channel. He's really, really close to hitting a huge milestone. So do it. And sleep well.
Do it. The power of Christ compels you. Bye.
Bye.
Oh yes, I've been meaning to put that up on my community page. There is in fact a sovereignty bingo card, and eventually, if I can actually get some videos that are not like branded or other people's channels, I'm more than happy to sit down and play sovereignty bingo. I've got no issues with that.
I'd love to see
There's
that
only-
bingo card. They're so whiny. Like they're like
Oh,
they
yeah.
do that whole high pitch making a scene. You know, like oh god. There's
The
some...
Sovsit movement was created by Big Auto Glass.
Now there's a conspiracy theory that I could subscribe to.
Was the jury present when they showed footage of the DA mouthing with the totally not coach snitch? Also, opinion on the Friendly Geordie situation.
I don't think so.
Okay, one, Friendly Geordies I haven't paid too much attention to probably in the last couple of months, so I'm not sure exactly which situation you're talking about. Last I checked, his house had been firebombed, and I think he was still getting into arguments with Barillaro, however you want to pronounce it. I'm not quite sure what the newest drama is. I haven't looked. As for the jury being present,
No, they were not. They
No.
were present when they showed it. So they showed it to the witness.
Yes.
And the judge reviewed it, but they did not show it to the jury. So the jury was only present for the observation of, the witness looking at it and answering questions about it. So I believe they might have heard audio played back from it, but they did not see the video.
yeah, I'd need to go.
That's
back
my
on
understanding.
which I unfortunately, don't have them in front of me. All right, let's have a quick watch of this one, and then we'll go to Zoom Court. Sovereign citizen who decided not to appear for court completely ghosted just because he felt that the court didn't have jurisdiction over him.
Well, that's going to end well.
LAD. No, excuse me. What's your name again? And your ID?
Yep.
Okay.
All that. Now you're under arrest.
Why? What's a crime? What's a crime? What's a crime?
You've been told.
What's a crime?
You're under arrest.
What's a crime?
Come on, out of the vehicle. Let's go.
Excuse me.
Out of the vehicle.
You are assaulting me now,
Out of the
okay?
vehicle.
You are assaulting me.
Let's go.
You are assaulting
You're
me.
under arrest.
You are assaulting me.
Turn around.
You are
Drop the
assaulting
gun
me.
back.
was that I'm not a piece of paper. I do not consent. I'm not a US citizen. Specifically in this case, this was in South Australia, so no, he very much wasn't a US citizen. If only Brooks knew he just didn't have to show up. I know, right? So where are we? Let's pull this one up. Alrighty. You are assaulting me. Hey, Mandy, how you doing? No wonder they thought this guy was drunk. His steering wheel was on the wrong side of the car. Oh, for God's sakes. Alright.
When we were previously
Oh,
on
I
the
started that early. Subset goes to judge, returns from the other side. This ought to be good.
All right, we have Mr. Mattson back with his audio connected now. When we were previously on the record, Mr. Mattson dropped out of the Zoom session. That I'm not entirely sure exactly what time that happened. Yeah,
He's having a
so
snack.
we
I love this.
discontinued the sentencing hearing at that time. Mr. Mattson, I believe, logged back in sometime around 9:35 when
He's gone again.
I was
just leaves
conducting another hearing.
The judge isn't. Oh, there he goes. So the
And,
judge didn't notice.
That was when I noticed someone in the waiting room that was labeled Robert's iPhone, which is what Mr. Manson's iPhone is labeled here this morning. I did bring that device into the Zoom session. When I noticed it, the camera was off, the audio was not connected. I did leave that there for a few minutes and then placed him back in the waiting room because the audio was not connected and continued on with my other hearing. I will say that I believe he remained in the Zoom waiting room for 20 or 30 minutes and then disappeared from the waiting room. So I do acknowledge it appears that Mr. Mattson tried to log back in to continue the sentencing hearing. We weren't able to make that happen, so I continued on with my other hearing, but we have everyone back with us now. Mr. Mattson, we are in a court proceeding right now, and so I'm going to ask you not to eat anything and to remove your hood, please.
Sorry.
All right, I'm going to ask you to remove your hood also, Mr. Mattson.
Hang on. Did the daughter admit that she lied on the stand? Did I miss something? Not that I heard. She hasn't been back on the stand, has she?
No, it was a statement from since that police officer that was the rebuttal, since he went out of state suddenly. The prosecution and the defense agreed on a statement where she had told him on May 19th or 20th about something like the gun had never been in Wisconsin. She had never seen it outside of what was it, California.
So that was
And one other thing. So it was contradicting statements from that police officer about the daughter's testimony.
Interesting. Okay, so that
it was just a stipulation essentially.
Nice and convenient that he was out of state then to provide that information. Hempland at TX gifted 10 memberships. Thank you so much, buddy. I very much appreciate that. Sorry, but I wouldn't take a court proceeding on Zoom seriously either, nor would I even participate in one. If you want court rules and decorum, hold courts in court. Okay. Motor saw. Oh, damn it, Jacob. I'm going to have to open up the stream. Thank you, people, for gifting memberships, but I can't see them. Let me play this and then I'll... shit, where'd the video go?
Is that guy's name Manson or Madsen? The Zoom guy, Robert's iPhone. I think they are addressing him as either Mr. Manson or Mr. Madsen.
I'm assuming Madsen. If not, you'd be damn well changing your name. All right.
Thank you. So we had been through the sentencing procedure. I had
Damn, Jake is proud Marjorie with
given Mr.
20 gifted
Madsen
memberships. Thank you.
an opportunity at allocution and was starting to announce the sentence. And so I will continue with where we left off. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record here this morning. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. Mr. Madsen pled guilty to one count of controlled substance, attempted possession of cocaine, heroin, or another narcotic of less than
All right, so theoretically we've got 10 minutes before we're back in court anyway, guys. So hopefully this will... Oh, come on.
$25 grams pursuant to a plea agreement which dismissed
no worries, Chappie.
one count of possession of cocaine, heroin, or another narcotic, dismissed one count of driving the license suspended, and one count of
I know you can own them in various
alcohol
places.
open container. I believe, am I correct, Mr. Daly, there was there a kill-brew agreement in this case to no upfront jail?
I didn't believe there was a kill-brew in this agreement, Your Honor.
I'm sorry, Mr. Daly, was that a yes or a no?
No.
Okay. So the agreement was to one count of attempted possession of a controlled substance, dismissal of the remaining charges, and that was apparently incorrect. There was no sentencing agreement in this case. This is Mr. Madsen's first felony conviction. He does have 4 prior misdemeanors. Those are all from 2015 or earlier. He has 2 2015 cases and a 2002 and a 2001. And so the recommendation in this case from the probation officer is for a period of 1 year probation. And I think that, well, it also, I should say, includes restrictions on alcoholic beverages and substance use. And I think that those provisions of terms of probation are appropriate given Mr. Madsen's Compass Needs Assessment scores. He did rate as highly probable in the categories of substance abuse, family criminality, residential instability, and social environment. He does have a substance abuse history of cocaine, fentanyl, painkillers since 2005. I think that it is appropriate to try to get Mr. Madsen some help for his substance abuse problems.
Are you telling me something's supposed to happen in this video? Sometimes it does, sometimes it doesn't. Sometimes they absolutely lose their shit. Sometimes it's just guys wasted out of their head.
Mr. Madsen's going to be willing to comply with the terms of his probation. He has, in numerous court hearings in this case, made a number of what he believes are constitutional and jurisdictional arguments that have absolutely no legal merit whatsoever. And he continued to challenge the court's jurisdiction here this morning. I understand that that may be an honest belief that Mr. Manson has. And I don't know where it comes from, but I will say Mr. Manson would be far better off taking legal advice from Mr. Daly than from wherever it is that you're getting it to make you believe these arguments, because as I've ruled repeatedly, there's just no merit to them. They're not rational or coherent arguments under the law. And the concern that that raises with me is that Mr. Manson, if he does not believe this court has jurisdiction, why then would he follow the terms of his probation? And so if that's the question, then the question I have to ask myself is why would I put him on probation if there doesn't seem to be any indication that he would follow the terms of the probation? The other side of that coin is that I think a lot of this stems from Mr. Manson's substance abuse issues, and the better way to get him help for his substance abuse issues is to put him on probation and get him into some kind of services to help him deal with that. So ultimately, Mr. Manson, I'm going to give you a chance at probation, and I hope that you are willing to comply with the requirements that are outlined in terms of your probation, which I'll read to you word for word in a moment so that you're aware of them. If you choose not to comply for the reasons you've stated or any other reasons, you can rest assured you're going to find yourself in violation of the terms of your probation. And then I am going to be imposing other penalties, meaning for you jail time. And I'll just tell you now, it'll be a short leash, because if we continue down this road, I'm already suspect of your ability to comply. So any violations are just going to confirm that for me, and you're going to find that I'm going to lose my willingness to give you a chance. So it will be the sentence of the court that you serve a period of probation for 1 year, that you serve 29 days in the Lenawee County Jail with credit for 29 days served. You must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site, unless the field agent has first given you written permission for your employment at a specific location. You must comply with the requirements of drug and alcohol testing as directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. And you must present proper identification at the time of testing.
Okay, this is boring as sin. I also have a police stop that turns a little bit nasty. Maybe we'll move to that. Just throw a few ones in the chat if you'd rather watch something else, guys.
Controlled substances or drug paraphernalia unless prescribed to you by a licensed physician. You must not be with anyone that you know possess those items. You must complete an outpatient or residential substance abuse treatment when you are referred by the field agent. You must complete a substance abuse assessment when you are referred by the field agent.
Yes, the defense has arrested.
Per month supervision fee.
All right. Damn, that Zoom call was dry. They usually a lot better.
2022. A Racine County Sheriff's deputy was monitoring traffic when they observed a vehicle traveling at a high rate of speed in Racine, Wisconsin. The deputy's laser unit displayed a speed of 43 miles per hour in a posted 30-mile-per-hour zone.
We're going to be at the mobile gas station off of Spring and Osborne.
The The driver was identified as 31-year-old Kelly Zeminski and the passenger as 37-year-old Joshua Zeminski. Upon approaching the vehicle, the deputy noticed 4 children in the back seat when the vehicle only had 3 seatbelts in the back.
What does that plate come back to? Hi!
Why is he pulling us over?
Can you roll down this back window? Hi guys.
It's showing a gray Chrysler 300.
So I'm Deputy Buell from Racine County Sheriff's Office. I pulled you over for your speed. You know how fast you're going? What? So 44 and a 30. Copy, thank you.
Definitely gonna take that before disputed because that's not what I stood on there.
Okay, that's fine.
I mean, it's fine. You can give me the ticket. Oh, that's just my insurance.
Yeah, I need your driver's license. Yeah. Who's the registered owner?
I am.
You're the registered owner?
Yeah, I'm still waiting on my plates to come in the mail, but my registration. Where's my? Oh,
Megan, thank you very much for the raid.
The what?
I gave my title to his mom.
It's our car.
The registration.
I gave it to her. It's in the goddamn hand.
Okay, sounds good. So you're Kelly?
Oh, Megan,
Okay. Do you have your driver's license?
I gave it to her.
She's looking
For your ID?
Oh, no, I don't have an ID on her.
Okay.
She has a license. I don't need to give you my name.
You just said it's your car.
It's my
Her car. I never said it was my car. It's her car. I'm her husband.
I don't know why you're being so argumentative with me.
Because I have to go to work.
Right.
I don't have time for this.
You're going to work with all the kids?
We're going
No, I'm
home.
taking them home and then I'm going to work. I work at 8 p.m. I have to shower and stuff. I took my kids to the beach because that's what we do on holidays.
Okay. All right. How old are the kids?
How is that, man?
Blue cameras at a bunch of Wisconsin Kenosha. Fantastic.
You don't know the age. You don't.
We have a lot of kids. Is this shit necessary? Why didn't it take this much?
Got a rescue on at the Riverview Manor, 580 Madison.
When did you buy the car?
A life alert alarm.
What?
Contact was made
A month ago?
for a 60-year-old female.
Me to call the guy that sold it
Feeling
to us?
nauseous and
No.
kidney change. I'm gonna have
I didn't ask you to do that. Do you have that stuff? Do you have any weapons in the car you know about?
No.
No? Okay. Any drugs in the car?
No.
No? No marijuana?
No.
No cocaine? No heroin?
I said no drugs, that's a no.
Okay.
There's no alcohol, no guns, no weapons, no knives, no drugs, no weed. I got some prescription pills.
Don't reach for anything. Okay? You guys are just being argumentative and that's a little
You're
weird.
asking a bunch of fucking questions that ain't shit. You pulled her over for speeding. You got her name. You've seen her insurance. You've seen her registration. And you're still questioning how old are my kids, this and that.
Well, I only asked because they have to be in car seats, and there's 4 of them in a 3-person seat.
Okay, I got a car seat in the trunk. Can you
Okay.
put a car seat in this kind of car and fit all these kids in here comfortably?
Well, you don't have the space to fit
Obviously
in the back
not.
seat.
That's why the car seat.
So
ain't
it's
in here.
illegal.
Then why do I
If you
take
get
it for
fucking
that
car,
too?
that doesn't excuse you from the
Okay.
law.
So do these kids?
No, it's just gonna-
You just have the one seat then, or
I got booster seats at home.
okay?
And
Are
I got a
they?
car seat.
Are those your kids?
They're
Or?
all my kids.
Okay. Do you have your ID on you?
I don't need to give you my ID.
Yes, you do.
No,
They're
I
your
don't. By law.
5'9". Can I have a cover? They're being argumentative.
You're gonna get arrested. Just give her your fucking.
I don't have an ID on me. I said it 5 fucking times. My name is Joshua Zeminski.
Should put the kids in the trunk.
I tried to give her my prescription pills, had my name on it. But by law, she told me, by law, you have a driver's license.
40 is fine.
I wasn't driving. You have a license.
How do you spell your first name, sir?
Joshua.
Joshua.
Yep.
Joshua. Your middle initial.
Joseph. J.
J. Your last name.
Zeminski. Ziminski.
Zeminski.
Yes, ma'am.
What's your date of birth?
Would you like to see my prescription pills from the doctor?
They're fine.
Oh, no, I took them out.
You gave me your name. I don't need to see your prescription.
I'm frustrated. I got a lot of shit going on. Fucking, I don't got time to get to work.
Okay. All right. Well, why don't you guys just stay in the car for me? All right. I'll be right back. Thank you. You're being extremely argumentative. She said I didn't pull her over for speed.
Would you stop
For speed. So 43 and a 30. So she was argumentative right off the start. And then there's 4 kids in the back seat and no car seats. There's a 3-person seat back there. So.
What's their problem?
We're only gonna write new tickets for the 2 kids that
that are young enough to be partners, right? But the other two are. Okay, well you still, like I said, you still have two of them. Saying, don't write me tickets for all four, since only two. Gotcha. Hey, don't want us to smell like. Too bad we don't have a canine. Too bad we don't have a canine.
Kelly and Joshua have an extensive criminal record, but they are mainly known for their involvement in the Kenosha protests and riots in August 2020. Both were seen starting fires and blocking law enforcement vehicles during the riots, as well as Joshua firing a gunshot in the air.
The side window's pretty dark too.
Oh yeah, they're like the same color. You can't see inside at all. And then when I first stopped him, I didn't even approach the car. He's hanging out the window. Why'd you stop us? Yeah.
Negative. It was a make-it case. We got the information from Walmart.
She can't drive with all four kids in the car like that, so I guess she can't go anywhere either.
No, we're on a traffic stop. What? What for what?
How long does it take to make some tickets?
To what?
How long does it take just to make some tickets?
As long as it needs to. I said, how long does it take to write some tickets? I said, as long as it needs to.
Can you go test their tint? Thank you.
Which window?
The front and the back.
Can you roll up your front window a little bit?
Can I roll up my window?
Yeah, can you roll it up just a little bit?
Oh, God, the fucking tint meter. What?
Alright, that's good.
Being asshole, they're gonna test for everything.
51 front, 4 back.
Kelly was cited for excessive tinting, operating under suspension of registration, and violation of child safety restraint. Second offense. Joshua was also cited for violation of child safety restraint. Second offense.
Okay. So, a couple things here. You got your citation for the violation of child safety restraint, which, looking through your history, this is the second offense for you. So you got one for that. You, sir, got the other one for the second child. So you got a citation as well. Okay. And then your registration is suspended due to due to 2 unpaid parking tickets in the city of Racine. So you got a citation for that.
How is my registration suspended when I just registered the car like a week ago?
I don't know. You'll have to work that out with Racine. It just says it's suspended due to
You
unpaid parking
tell him to
tickets.
pay his motherfucking shit because I ain't
Okay,
doing it.
and then you got another one for excessive rear window tinting because this is at 4%.
My law is 35% in Wisconsin, and I've seen you meters at 54.
The front one.
The back said 50. 4. Can I see it again?
Sure, that's fine. So you don't have to go to court for these if you don't want to. But if you'd like to, your court time's going to be July 21st at 2 p.m. in the afternoon, okay? So I'll give you these. I put your ID in there, and then this is his.
Here, babe.
Yep.
All right. Do you have any questions?
Nope.
Okay. You can't drive because they don't have proper restraints.
I have my sister on her way.
I guess I
And we're
forgot
back.
to do that.
Apparently.
Then, oh man.
Yeah, what's happening? Meh. It's a little off. Oh well.
I
Flora Prom did that
also
just to annoy me.
didn't number the pages. But anyway, has everybody received copies?
Yes.
A couple of preliminary matters. There was a request by the state for prisoner status as an issue, and I'm not giving that because that refers to cases where the status as a prisoner is actually an issue for when, for example, battery by a prisoner.
Judge, I don't think we asked for that.
No, I think that could be taken out.
Done.
Done.
All right. You didn't send that?
No.
Okay. Blame shifting. All right.
Oh shit.
The first page?
Nothing on the first page.
That's the standard. Then page 2, information not evidence, the charges. Then
Judge, in regards to page 2, and I think the state can speak more to this, is they had proposed specific language for counts 1 and 2. The defense would have no objection to that, so I'll let the state be heard, but I know that what was included starting on page 2 was different than what the state had submitted.
you're correct.
Judge,
I think they're arguing
looking
that,
at
yeah.
the language for stalking, because there are so many and/or propositions, it becomes so cumbersome to read that I wonder if the court would be willing to look at our suggested proposal, because it removes all of the essentially or ones to make it more streamlined and understandable.
Why do you charge it that way?
It's
That's how the information comes to me. That's the charge against the defendant.
because that's how it is generated in our program, and I can't speak to that. What I can speak to is, I think, the same level that I'm sure the jury feels, which is all of the or this or that. I mean, it becomes very cumbersome. So when I streamlined the proposed ones, it specifically has fewer, obviously, or situations, but also it removes a lot of the potential ways someone can stalk someone else that don't apply here, which is what the pattern instruction
It's
actually
reflect,
calls
no,
for,
it
is to be
automatically
more
deletes
specific.
links
And
if
we,
you try and post
we
them in
wouldn't
your
have all
mod.
of these problems had you charged it, because you recognize the problem. The problem is that you divided it in 2 separate instructions, even though there are 2 counts, but I prefer to instruct once on the crime.
Okay.
You have one for Sadie Beecham and one for Mr. Gutierrez.
Correct. So
I propose to give only one.
if the court would be willing, I have access to be able to edit it here. If you would prefer the language of where you have it as of another, and to take out specified victims' names for counts 1 and 2, I believe that then we could go with the Sadie Beecham pattern instruction, which I believe would cut down on a lot of reading for the court in terms of all sorts of additional options. So if the court's willing to do that, I will make that change here while we sit here and save us all some time.
You make it so I can't even argue with you.
Fantastic.
All right, yeah, please do that, because that, the biggest problem was covering all kinds of areas that didn't need to get covered, and the second problem was doing it twice back to back. But if you cure up those problems, then I'll be delighted. So then, and in the meantime, you also had submitted and both because of some CCAP issues in copying, I didn't eliminate some of those various ways in which the crime can be committed that you spoke of before lunch. And so if you can strike off those that are inapplicable,
Will do.
yeah, that'd be great. Okay, so then let's skip ahead to,
Judge, you're gonna need to give her a moment to switch those up, though.
all right.
She will not be
I
able to
thought she was
listen.
ambidextrous.
No, we can probably move on. Well, I'm just having to change names. So and I know Ms. Muller and I have kind of already went through some of the issues we saw, so I can rely on her to yell some of those out.
Yeah.
Okay.
Oh, there we go.
In the meantime, is there any problem with the count 3 instruction?
Yes, the court has the first name of Mr. Gutierrez as Rosales. It should read Rosalio.
Well, don't blame me, that's the computer.
The computer.
Yeah,
Yeah.
you're right.
But besides that, I had no other edits for page 6 or count 3.
Okay. And then the 4th count?
So under the 4th count, under the law, it says, hold on, sorry, my computer is being all annoying.
Must be the
It
room.
says, it's the 4th count, and then it says between the dates in the city of Kenosha, Kenosha County, Wisconsin, hit a court, so the defendant needs to be added into that.
Oh, I changed did hide. The district attorney is still using language like to wit.
No,
And-
sure,
and-
but it doesn't have a
and it's-
subject.
Yeah, you're right. It creates a problem when I change it without putting the defendants, because, yeah, you're right. So I'll put in the defendant hit a corpse with the intent to avoid, etc.
Yes, thank you, but then there were
Technically,
no
you'd still
other
have the conviction recorded on him, but it's a
substantial
damn good
issues
reason
with
for
the
an
remainder of
appeal.
that instruction.
Okay?
The next issue that I had come across was on page 11, Judge. The stricken testimony instruction was there for a second time. It was a repeat.
Well, I originally I thought I had taken it out because there was stricken testimony, yes. Thinking that there wasn't, I took it out, and then I noticed it was submitted, so I put it back in. So I'll strike it once.
Yes, thank you. And then let me know when you're ready for the next one.
Okay, improper questions. Well, in evidence defined improper questions, objections.
I'll be right back.
That was all fine, Judge? And if you're
That's where the second time the stricken comes in. Okay.
correct.
Then testimony of a witness granted immunity or other concessions.
Yep,
Any problem with that?
no.
Prisoner or witness.
We're taking that
That's the
out.
one I don't propose to give. The cautionary instruction.
Yes.
And I noticed I had put it in at the end so I wouldn't forget about it when I first was working on these, so that second appearance way at the end will not be involved in the case. Evidence of other conduct, any objection to that?
No, and I'll just
Oh, that's
note,
one, yeah.
I'll just note that that was the proposed language that the defense had provided to the court.
Good. I was able to import that.
Good.
Credibility of a child witness,
Yes, that was
Okay.
requested by the defense.
any objection? Agreed facts, any objection?
Nope.
Exhibits, any objection?
Yep. No kidding.
Circumstantial,
Nope, that's fine.
no objection.
No objection.
Remarks of counsel,
Fine.
Fine.
closing arguments, weight of evidence, jurors' knowledge, and expert opinion, any objection?
No objection, Judge. What the state and myself did confer on, though, was as it relates to expert opinion, we believe 205 should be included because there were a couple of hypothetical questions that were proposed to experts during the trial. So we would just ask that 205 be inserted, and the standard language of that instruction is fine.
Agreed?
Yes.
Let's see, credibility of witnesses, any objection?
Nope, it's fine.
No.
Oh, except that the very last paragraph on that page, the defendant has testified in this case, I won't give that, of course.
Yep.
Impeachment of witness by prior conviction.
So that number, it says, evidence has been received that 2 of the witnesses, the state and myself counted that there were 4 witnesses that had prior convictions. So just to change 2 to 4.
Well, actually, what I usually do, and I'm sorry I put the 2 in there, I usually say evidence has received that some of the witnesses.
I think that's fine as well, but the number 2 is.
Either's fine, but 2 is just inaccurate.
Yeah. Defendant elects not to testify, you did request.
Correct.
Okay. The closing instruction,
Looked fine.
well, actually, it's not. I turn the page here and first thing I see, the President of the United States, and that's from a different trial. I
Oh, I am seeing that.
gave some instructions about the freedom of the jury to do what they wanted, and not what.
Wonder what trial that was, Judge.
Yeah.
So I will give
Standard one?
either the standard or something very close to it. Then verdict submitted and unanimous verdict. Any objection?
No. And no objection there, Judge.
And then that remainder of the questionnaire, that's all out.
Yeah, and then that 275 that's at the end will just be taken out.
Yep.
I didn't have any other notes. I don't know if the state did.
I did not.
Okay.
And Judge, I'm sending to your clerk right now that jury instruction for counts 1 and 2.
Very good. Thank you. Thank you.
Yeah, these are the court instructions to the jury, and it seems like they have not much to disagree about.
Well, yeah, print one too. Well, print the copies for them too. So make 4 copies. Huh? It's the same problem I had before. That's, I think that's a CCAP problem.
Copy and paste on something else and see if that takes care of whatever this is.
See in the chat, what's the weather like in Sweden? It's cold, dark, wet, like it is 9 months of the year, and summer is the best day of the year.
Are you able to open it?
Just print it. We'll get it open later.
I can't print it because I can't open it.
Oh,
I will print it to my office. I will run and go get it.
The best day of the year, that's good.
Our summers are, with global warming, are starting to get quite nice, actually.
Oh, cool. Vince, Aussie. Oi, oi, oi.
might work.
Aren't you glad that you took the afternoon, Ozzy?
Oh, I'm positively riveted right now, I'm not going to lie. And thank you to everybody that's sticking around for this.
They could at least disagree on some of this, but there aren't much disagreement about the instructions.
Oh, look, if they agree on them all, then I can go back to bed.
Yeah,
Well,
I'm
it's not what I was
sticking out.
expecting.
Yeah,
I mean, they
I'm
disagreed about everything else, so. Sorry, Nicholas.
Oh, no worries. I'm waiting to see if there is something beyond this, because if it isn't, I have a video to make about my mock defense closing that I will put out sometime tomorrow morning, my time.
Oh, I'm looking forward to that. That'll be great.
Here, I have an extra hard drive. This way, Judge.
She can't put a foreign hard drive into the state system.
Yeah, I don't know. Well, looks like you'll have to retype everything then, Judge.
Actually, if
You can scan it in pictures.
which paragraph did you take out? Yeah, I like that idea.
To scan it in?
Well, I can scan it into my phone.
Why would that work?
I mean, if you send it as a PDF, I
No,
can
so
send it
I'm having a physical copy run over, and then we can.
I see what she's saying now. She's saying maybe here, I got you.
But I don't know if it'll let.
Because before when I sent to PDF, it didn't work. So I'll send that to you right now as a PDF.
What a bunch of dinosaurs in here, you know? At least she knows what
You of all people are saying that shit.
she knows what she's doing.
I thought maybe if you send it in a different Word format I'd be able to open it.
I'm gonna try this.
I can open older versions of Word, newer versions of Word.
Just send it to the PDF.
And I don't think he's gonna be able to edit it.
Yeah, you can.
If she has, she has abilities, I don't think he does. We'll find out.
So you can then convert it back to a Word
I don't know if I
document.
have that ability.
Well, even if I have a PDF, that should be fine.
Okay, I'm gonna send it to you, Judge.
Except that's, let's see, that looks like the one in the pattern instructions, and that would be unedited.
You know, honestly, I have it, but it doesn't, I don't have the Word conversion.
But you can still copy and paste it.
Well, you can do that, but
Yeah.
I think it's all.
I may have missed a few of them, sorry, Judy.
I said it.
Can't convert it.
No, it won't let me know. Where do you see that?
On the right-hand side.
Where?
Right here?
Yeah, but it won't let me. It's gonna say you
Oh,
want to
that you,
purchase.
you have to purchase.
I'm not
the-
seeing it.
Yep, yep. Did it work?
I said, yeah,
No.
I don't know if that's right.
CCAP won't purchase the plan we need to convert it. Thank you.
You guys remember this? This is a substance called paper.
Yeah.
Yeah, we can do the electronic version later. We've got everything set now, I think. Any other concerns with the instructions?
Not that I'm aware of. No.
All right, let's call the jurors.
And you're gonna ask them about 8:30, Judge?
I am.
Just play joke, 8:30 on Thursday.
Hello.
Would you come down, please?
Yes.
What's she going to say? No, we're busy?
Well, that was exciting.
Yeah, but look, at least it's over and done with, so they'll read out the jury instructions, jury will go into deliberation, and we'll be on jury watch, basically, people, so...
Closing first.
Oh, right.
They read the
closing's
instruction
right.
and
Damn
then
it.
it's the closings. But
Okay,
I hope closings are tomorrow.
Yep.
Yeah, I would imagine they would not be today. Guess that's it. Not a lot to say.
Hmm. I saw that Steve Gosney was in the chat. I don't know if he's still there.
He's just heading out.
Okay, of
Bye,
course.
Steve. Bye, Steve.
Bye, Steve.
See you, Steve.
I think he said he was sick. Feel better.
Mhm. Yeah, I'm still a bit surprised over that the defense didn't call.
Just to acquaint you with the schedule going forward, you're almost done. I'm gonna instruct you on the law this afternoon. It's gonna take about, I'm gonna say half an hour. And then you'll be released for the day. And then I'm gonna ask that you return tomorrow at 8:30. Is that convenient for everybody? And we'll hear the final arguments of the attorneys at that time. We hope to be done by noon. And have the case in your hands then. That's not a promise, but that's the hope. Like when I told you it was going to be 2 weeks. It was a hope, and I expect a better result this time around. And I'm going to instruct you now on the principles of law, which you should follow in considering your evidence and in reaching your verdict. It is your duty to follow all of the instructions, regardless of any opinion which you may have about what the law is or what the law ought to be. You must base your verdict on the law as I give it to you in these instructions. Apply that law to the facts in the case which have been properly proved in the evidence. Consider only the evidence received during the trial and the law as given to you in these instructions, and from these things alone, guided by your soundest reason and best judgment, reach your verdict. If any of you has any impression of my opinion as to the innocence or guilt of the defendant, you must disregard that impression entirely and decide this case solely as you view the evidence. You are the sole judges of the facts, and I am the judge of the law only.
Okay, I'm going to pop out to start my mock closing video, but
keep in mind that the information is nothing more than a written formal accusation against the defendant,
Bye, Nicholas. See you tomorrow.
charging him with the commission of one or more criminal acts. You are not to consider it as evidence against him in any way, and it does not raise any inference of guilt. The information contains 4 counts of charged unlawful behavior against the defendant, and to each of these counts he is under a plea of not guilty, which is a demand that the state prove every element of each charge beyond a reasonable doubt. Counts 1 and 2 of the information charge that between the 1st of August of 2020 and the 17th of May of the same year, at the city of Kenosha in this county, the defendant intentionally engaged in a course of conduct directed at a specific person, which caused that person and which would cause a reasonable person under the same circumstances to suffer serious emotional distress or to fear bodily injury or death to herself or himself or to a member of his or her family or household, and where the defendant knew or should have known that at least one of the acts that constituted the course of conduct caused the person to suffer serious emotional distress or place the other in a reasonable fear of bodily injury or death to himself or herself or a member of his or her family or household, and where the defendant's acts caused the other to suffer serious emotional distress or induce fear in the other of bodily injury or death to herself or himself or a member of his or her family or household. Stalking, as defined in the Criminal Code, is committed by one who intentionally engages in a course of conduct directed at a specific person, which causes that person to suffer serious emotional distress or to fear bodily injury or death to himself or herself or a member of his or her family or household. It did not come through. What I've got here didn't come through. What was sent to me?
No, the printed copy.
Remember, we gave you a printed copy that we thought was.
Hang on, is he reading from the wrong set of instructions?
This is a printout of 1284 is what it is.
Right, but it's altered in the way that has the specific things we wanted in the instruction. So it has the...
That I understand. This was, the parties discussed and reached an agreement on this, so this is from one side or the other.
Much appreciate that.
So we know electronically it didn't work, Judge, but we were hoping that we thought the court was going to read the printed copy we provided.
Well, actually, I see now in the latter section, it does remove some of the paragraphs. That, okay. Stalking, as defined in the criminal code, is committed by one who intentionally engages in a course of conduct directed at a specific person that causes that person to suffer serious emotional distress and that would cause a reasonable person to suffer serious emotional distress, and where the actor knew or should have known that the conduct would cause the person to suffer serious emotional distress. Before you may find the defendant guilty of either of these offenses, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. First, that the defendant intentionally engaged in a course of conduct directed at another. Intentionally requires that the defendant have acted with the purpose to engage in a course of conduct directed at the person alleged to be a victim. Course of conduct means a series of two or more acts carried out over time, however short or long, to show a continuity of purpose. Acts that you may find constitute a course of conduct are limited to: 1, maintaining a visual or physical proximity to the victim; 2nd, approaching or confronting the victim; 3rd, appearing at the victim's home or contacting the victim's neighbors; 4th, entering the property owned, leased, or occupied by the victim; 5th, photographing, videotaping, audio taping, or through any other electronic means, monitoring or recording the activities of the victim. This subdivision applies regardless of where the act occurs. And 6th, causing a person to engage in any of the acts described above. The second element is that the course of conduct would have caused a reasonable person to suffer serious emotional distress. Suffer serious emotional distress means to feel terrified, intimidated, threatened, harassed, or tormented. This does not require that the alleged victim have received treatment from a mental health professional. To determine whether this element is established, the standard is what effect the course of conduct would have had on a person of ordinary intelligence and prudence in the position of the alleged victim under the circumstances that existed at the time of the conduct. Third element is that the defendant's acts caused the alleged victim to suffer serious emotional distress. And the fourth element is that the defendant knew or should have known that at least one of the acts constituting the course of conduct would cause the alleged victim to suffer serious emotional distress. You cannot look into a person's mind to determine intent or knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent and knowledge.
A little bit.
If,
yeah.
as to the first or second count, you are satisfied beyond a reasonable doubt that all four elements of this offense have been proved, then you should find the defendant guilty on such count, either or both, or neither.
Okay, fair.
If you are not so satisfied, then you must find the defendant not guilty on that count. The third count of the information charges that on or about the 17th of May of 2020, the defendant caused the death of Rosalio Gutierrez Jr., Rosalio Gutierrez Jr. with intent to kill him. Intentional homicide of the first degree, as defined in the criminal code, is committed by one who causes the death of another human being with intent to kill that person or another. Before you may find the defendant guilty of intentional homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, that the defendant caused the death of another human being. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill the other. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the fatal act. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the fatal act. Intent should not be confused with motive. While proof of intent is necessary to conviction, proof of motive is not. Motive refers to a person's reason for doing something, while motive may be shown as a circumstance to aid in the to aid in establishing the guilt of a defendant. The state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If, as to this third count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being with intent to kill, then you should find the defendant guilty of intentional homicide of the first degree as charged in the information. If you are not so satisfied, then you must find the defendant not guilty as to that count. The fourth count of the information charges that between the 17th of May and the 19th of May of 2020 at the city of Kenosha in this county, the defendant hid a corpse with the intent to avoid apprehension for a crime. The Criminal Code of Wisconsin is violated by one who hides or buries a corpse with the intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, that the defendant hid a corpse. Second, that the defendant hid a corpse with intent to avoid apprehension, prosecution, or conviction for a crime. This requires that the defendant have acted with the purpose to avoid apprehension, prosecution, or conviction for a crime. If, as to this fourth count, you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty of hiding a corpse as charged in the information. If you are not so satisfied, then you must find the defendant not guilty as to that count. In reaching your verdict, examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not required to prove his innocence. The law presumes every person charged with the commission of a crime to be innocent, and this presumption requires a finding of not guilty unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means
No,
a doubt
they're
based
currently
upon
reading that through the
reason
jury.
and common sense.
Closing statements will be
It
tomorrow
is a
morning.
doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt. Evidence is defined first as the sworn testimony of witnesses both on direct and cross-examination, regardless of who called the witness. Second, the exhibits which have been received, whether or not they accompany you to the jury room. And third, any facts which the lawyers have agreed or stipulated, or which I have directed you to find. Anything that you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at the trial. Disregard entirely any question to which I did not permit an answer. Do not guess at what the witness's answer might have been, and if the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence.
Well, Marshal, you tell your co-worker that he's living up to his name, Mr. Sauer.
Attorneys for each side have the right and duty to object to what they feel are improper questions asked of witnesses and to the receipt of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing testimony or other evidence to be received over objection, I did not mean to indicate any opinion as to the weight of that evidence. The weight of the evidence is decided by the jurors alone. You jurors are the sole judges of the credibility of the witnesses and of the weight of the evidence. During the trial, I have ordered certain testimony stricken, and you must disregard all such stricken testimony. You have heard testimony from a witness who may receive concessions from the government in exchange for his promise of cooperation. This witness, like any other witness, may be prosecuted for testifying falsely. You should consider whether receiving concessions affected the testimony and give the testimony the weight you believe it is entitled to receive. Evidence has been presented regarding other conduct of the defendant for which he is not on trial. Specifically, evidence has been presented that the defendant was involved in growing and selling marijuana and growing and using psychedelic mushrooms. You may not consider this evidence to conclude that the defendant has a certain character or a certain character trait and that he acted in conformity with that trait or character with respect to the offenses now charged against him in this case. The evidence was received on the issue of witness credibility. You may consider this evidence only for the purpose which I have described, giving to it the weight which you determine it is entitled to receive. It is not to be used to conclude that the defendant is a bad person and for that reason that he is guilty of the offenses now charged against him. The testimony of a child should be weighed in the same manner as testimony of other witnesses. Considerations of age, intelligence, ability to observe and report correctly, ability to understand the questions and to answer them, sense of duty to speak the truth, conduct on the witness stand,
Sorry, Bob, I'm not
interest,
the person
appearance,
asked that
and
one.
other matters varying
Ethics varies
upon
from district to
credibility
district, let alone from
applied
state
to a
to state.
child witness in common with all the other witnesses. The district attorney and the attorney for the defendant have stipulated or agreed to the existence of certain facts, and you must accept these facts as conclusively proved. An exhibit becomes evidence only when it has been received by the court. Exhibits which may have been marked for identification and not received are not evidence. An exhibit once received is evidence whether or not it accompanies you to the jury room. It is not necessary that every fact have been proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find him guilty. Remarks of the attorneys are not evidence, and if their remarks suggest certain facts which are not in evidence, disregard the suggestion. You should consider carefully the closing arguments of the lawyers, but their arguments, conclusions, and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under my instructions. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness, or even of several other witnesses. In weighing the evidence, you should take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, witnesses may testify only to facts. However, witnesses with specialized knowledge in particular fields may give opinions in those areas. In determining the weight you give to these opinions, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based. Only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based upon those facts should not be given any weight. It is your duty as jurors to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors: whether the witness has an interest or is disinterested in the outcome of this trial, conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity which the witness had for observing and for knowing the matters and things about which testimony was given, the reasonableness of the witness's testimony, the witness's apparent intelligence, bias, or prejudice, if any has been shown, possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony, and then give to the testimony of each witness such weight as you believe it is entitled to receive. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and experience in your everyday lives. You decide for yourselves the reliability of things said to you by others, and you should do the same thing here. Evidence has been received that some of the witnesses in this trial have previously been convicted of crimes. This evidence was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. We are going to hear the closing remarks of the lawyers in the morning, and then I will give you about 5 more minutes of additional instruction, and then the case will be turned over to you. We will have 12 of you go into deliberation, and that'll be done by, there's a tumbler over there on the window ledge that you may recognize from your church, or not, but the names of all the jurors will be put in there, and if we need to get down to 12, then the defendant will draw out one of the names to be excused. 8:30 tomorrow. And any question, anybody? Even though the evidence is closed, you need to keep an open mind until you've heard the arguments and those last few instructions. So please continue not discussing the case with anyone, not even fellow jurors. Don't read, watch, or listen to any account of the trial. And any questions? Have a wonderful evening, and we'll see you tomorrow.
All right.
Well, there we go, people. We officially have had jury instructions. We've had... Oh, God, that was boring. Chandler's pounding those back. Thank you very much.
2 down.
Brandon, good job.
I have met my quota, so thank you, Brandon. That was very generous.
B26 and B26. Okay, well, yeah, guess we'll be back, and oh god, that means I'm gonna have to get up early in the morning because I'm not gonna miss closing statements. Kangaroo news. No, look, I'm not gonna lie, guys, I'm not prepared for a law news and laughter, so what we will do is I'm gonna head over to the XXX Tentacion trial and listen to the verdict. Just
Anything further today?
No.
One way or another, we need to get the guy. I have to print instructions for the jury, so we need to clear this matter up somehow.
That's why they give him the printed copy.
When we get over there, we'll take another try at sending it to you electronically from our facility. See if that
Yeah, when they come over, and when I can see the pattern instruction numbers on them,
I will copy.
they're always corrupt.
I'll copy and paste it to a new Word document, moving that, and hopefully that will assist in this, but I will go make efforts on that.
Thank you.
Before you go, there's 2 exhibits that aren't in this. I don't know if you used it, I don't know if somebody checked it by mistake, and I don't think they were on my list. Okay, so I'm not put over CJ or so I'll fix all of that.
Yes, you have.
Okay. And then, exhibit 5 for the Facebook
Wow, that's an interesting close-up.
Mm-hmm. Stressed and tired. Look, I would be too. Like, this is easily the most stressful point of the day and the point of the trial for him, really. So, oh, bloody cook cage. But you know, it is what it is. So, as I was saying, I'll head over to the XXX Tentacion verdict that was given out today. And then, you know what, I'll probably close out from there and get some sleep, guys. But yeah, this should be mildly interesting to hear.
So how early are you going to have to get up for closing arguments?
I probably won't go to bed. There's not going to be any point. So.
All right.
Alrighty. Now this one does have pretty shocking audio, people. I'm going to have to turn it right up, so I'll turn myself and Chandler down, because this court has fucking shocking audio. Although apparently they sort of worked it out today, so we'll play it by ear.
Parties may be seated. Court will come to order. The parties and prosecutors are present. Ladies and gentlemen, good morning. Welcome back. I trust all of you were able to follow the court's instructions. Very good. All right, you may retire to resume your deliberations.
That was helpful. Who was unsubbed? Okay. Jump ahead then, because we're not going to see it.
I've only heard a little bit about this case, but I really haven't been following it. Have you?
Yeah, so I was covering this case from gavel to gavel until the current case came along.
Any of the verdicts.
So just quick rundown for anyone that is unaware of the case. XXX Tentacion was a rapper. He, on the day in question, went into... yes, Colin, I already have multiple sound boosters, but thank you. He went into the bank, tried to take out $250,000 in cash because he wanted to go to a motorcycle store and apparently splurge on however many motorcycles. They let him take out $50,000. He put it in a Gucci bag that apparently is also worth roughly $50,000. He goes into the motorcycle store. 4 guys recognize him. 2 of them go in, follow him around, and sort of case out the joint and that sort of thing. And as he is... So he doesn't really buy anything. They're in there. The guys buy the masks that they wear while they rob and kill him while they're there, which I thought was pretty ballsy. They leave the store and wait for him, but they go out and they park across the road at the next sort of like street, and they're waiting for him to leave the T intersection of the car park. As he's pulling out, they pull in from the side street, block him. 2 guys jump out. Both of them run around to the driver's side. One of them's both have guns. We've seen the footage, and they're trying to rob him. His uncle, who was there for protection, gets out of the car and runs faster than Usain Bolt to get out of the area, leaving him on his own. And basically, there's a bit of a scuffle. One of the guys runs around to the other side of the car, grabs the Gucci bag with the money in it. The taller guy with the gun and what is presumably a .22 rifle from memory, because we're about 8 days behind or so since I've paid attention to this entirely, people. Puts 3 bullets in him, I believe. They both then get in the car, drive away. After they drive away, a fan walks up and takes a selfie with his dead body.
Jesus.
Which I thought was very classy. They then get into a car accident. There's a bit of back and forth of cameras that were, and who picked them up and who did whatever else. But anyway, of the 4, one of the guys flipped and became a prison snitch on them. And we affectionately refer to him as Cheeseburger because he's a big chunky guy, I'm not going to lie. Whether he's still alive or not, we're not really sure. But basically, see, this is what happens, people. If you commit a felony with somebody, don't try and cut them out of the money, because that's what they tried to do. They weren't going to give him anything. In the end, one of the guys convinced them to give him $5,000 out of the $50,000. The others got like $15,000 each. So he flipped. He's been charged with second-degree murder, and as a result of his testimony in the trial, he's more than likely going to get a reduced sentence. And these 3, although it's technically 3 separate cases being tried at once, they all the evidence was obviously the same, but because they were being tried together, they couldn't point the finger at each other, which I think was a serious hindrance to the defense. But I don't really care, because each of the defense attorneys in this case have been slimy as shit. We had Dickless, we had Colonel Mustard, and we had the mob boss lawyer. Those are my affectionate nicknames for each of them. And Colonel Mustard was doing everything he could to bring Drake into this trial, to blame Drake, because there was some sort of beef between Triple X and Drake, which
I heard
is
about
a complete...
that. Yeah.
Yeah, so, you know, all he really had on that was, like, there was an Instagram post and something like that. But, and he damn well did everything that he could to try and cause his own mistrial, to try and backdoor Severance the case, so that he could try and blame it on the other 2, in my own personal opinion. I was disgusted with the way that the defense handled this case, I'm not going to lie. Prosecution, on the other hand, Madam Prosecutor in this case, she got balls. She was damn good at what she did. And Mummy Esquire, the second chair prosecutor. And this judge has been reasonably fair, I'm not going to lie. So that sort of brings you up to date in a very, like, Cliff Notes sort of version.
Thank you for that. That was actually very succinct and helpful.
Oh, that's all right.
It's better than watching, like, 37 hours of trial testimony sped up on,
That's true.
like 1.75 speed. Because then they all sound like chipmunks, so that's not really my favorite.
Mob boss lawyer, best of them all, was the most trustful. Yeah, it's like saying you're eating the best of a bad bunch of bananas.
You have good nicknames, though. I appreciate that. I like, I think D.A. Balsack is my favorite, personally. I might be a little bit biased, because I feel, like, very close to this trial now, and so it's like, I feel like he's my D.A.
No, that's perfectly fine.
So.
In this case, each of them had their reasons. Mob boss, from day one, looked like he was a mob boss lawyer, I'm not going to lie, okay? Colonel Mustard walked in wearing a stark yellow suit. Like, it was literally, he looked like a bologna sandwich had thrown up on him. And Dickless was just, he was doing things throughout the trial that just irritated me, so he got that one. Judge is ex-military, so he is on point. That is true. He did not put up with any sort of shit. I'm not going to lie. What? The court came back on Anderson? Are you serious? Well, it doesn't matter because the trial stream for Law and Crime has ended, so there's nothing there to watch. So.
Really? Was there anything on Court TV or?
Let me have a quick look.
Sorry, Brandon. I just got that message. I'll be right back. Let me grab something.
Let's see if they're actually showing anything. Nope, they got the teenage cheerleader murder trial. Oh, no shit! It's Fucci's, hearing. What am I doing? Why am I not watching that?
It does not. It does not, Your Honor. This is an attempt to bring in something that would not qualify as a prior criminal conduct. And for that reason, we're asking the court not to allow it at the sentencing hearing and allow him to have a fair trial. Fair sentencing, I would say. Thank you.
All right, state, yeah. Something else?
Just the only thing I would add for the record is the people
So
that
this is the
provided
trial
this
that I was going to be
information have
doing,
been deposed by defense.
where the guy
She has every opportunity to call
drew a
them. If there
conscience
were
and
other
pled guilty
juveniles
literally
involved
5
in
minutes
this
before the trial
conduct,
stream
they
was
were named
supposed
and
to start on
identified.
Thursday.
So I just don't agree with the stance that she has no ability to react or present evidence on these. These teachers have all been deposed, like I said, and she has equal access to them as we do.
All right. Let's move to the final motion. This is the motion in limine to prohibit the testimony of Dr. Gregory Pritchard.
Yes, Your Honor. Defense would move in limine to prohibit the testimony of Dr. Pritchard.
Yeah, so when he was 16, he offed a 14-year-old
State expert Pritchard was deposed on Wednesday, March 15th. And his testimony or his anticipated testimony would be on reliance of the discovery materials.
He did, right at the last second he pled guilty. This is in relation to the
Autopsy
sentencing.
investigation. And at no point is his reliance or his testimony going to be on the foundation of prior mental health evaluations. We know from the school records that there aren't any. So his testimony then wouldn't be within his field of expertise as a psychologist. Really what his testimony would be is a regurgitation of the discovery. And for that reason, Your Honor, we'd argue that it's improper for him, with his unsupported opinion, to testify before the court regarding the deposition transcripts, the crime scene photos, the medical examiner report. And his testimony, as anticipated, would be devoid and would then, in essence, Your Honor, mislead the trier of fact. Because what he's doing, Your Honor, in terms of what we would usually see with a mental health investigator or a mental health expert, would be some form of review and analysis of other reports, evaluations. But there aren't any in this particular case, and although it's heavily relied, he was only 14, and it's heavy reliance on pediatric records or the actual school records, there aren't any psychological evaluations. So what he's relying on instead is what he has are depositions, police reports, and the medical examiner report. And defense would argue that would be inappropriate for psychologists to come before the court and then opine as a psychologist about the nature of the offense based on photos and the medical examiner. So for that reason, Your Honor, we're asking the court to prohibit the testimony of Dr. Pritchard in this particular sentencing hearing that begins tomorrow. Thank you.
Thank you. State.
Your Honor, this argument by Ms. Peoples is quite unbelievable, and I'm sorry to say disingenuous. Ms. Peoples is extremely experienced and aware of what experts can rely on and use in criminal cases, forensic psychologists. Both parties do this in our careers on a daily and monthly basis. And Ms. Peoples is well aware that mental health experts largely rely on and review records, Sometimes they get to evaluate defendants, not all the time. There are plenty of
Sorry, Michelle, I will
death
come
penalty
back to
cases
Triple X.
under the old rules.
I got sidetracked
and
because I saw
where we weren't forced to file in 45 days to seek death. But under the old rules, there were times where the state didn't get the opportunity for the mental health evaluation if we didn't follow a certain set of rules. It never limited the state in calling a mental health expert based on an extensive record review. Dr. Pritchard also testified it is quite common in his practice that he will often be faced with uncooperative defendants. Defendants maybe who are claiming insanity, there's competency issues with. And if, he's not saying he would make an opinion in every case, but if there are enough records there and they're comprehensive and he's able to make an opinion on certain things, he will opine, and if he's not, he will state his limitations. And his report right off the bat.
All right, we are going to take a break now, as we always have to take a break, pay the bills, but they're arguing right now about whether the state expert, the mental health expert, can come in and testify, having not personally examined the defendant.
Right, and there are no previous mental health diagnoses of the defendant that he can rely on.
Yeah, and I think she's right. They always rely on a large
Everything.
amount and everything. So I'm not sure the defense has a leg to stand on this one. We'll take a break. We'll be right back in the courtroom on the other side. Keep it here on Court TV.
Hayden, you're muted.
Thank you. Yeah, so for anyone that didn't know, so this is the Fushi case, Aiden Fushi. Reasonably interesting one. As I said, I was going to cover this. I spent like 8 hours. There's a whole stream of me where people were sitting watching as I was doing like the background, all the prep work and all that sort of stuff, because I got really, really excited. And the little prick developed a conscience like 5 minutes before the trial was due to start. This one's interesting because the family were involved. The mum is also facing charges for interfering with evidence because she went in, found his jeans, tried to clean them, spoke to other family members and friends of the family who came around, showed them the jeans, and basically tried to dispose of the evidence. Yeah.
That was my understanding.
So...
the jeans were soaked in blood, and the mom tried to wash them as any good mother would do.
Yeah. This was the curse case. Yes, this was the curse case. and this kid's a little psycho. Like, I mean, even when they were speaking to like his girlfriend, to his friends from school, that sort of thing, they were talking about him hearing voices and just wanting to kill someone, and that he was going to kill someone and then he was going to keep killing people until he got caught. And it's just like, why did no one ever think to raise this with an adult?
Kind of reminds me of Nicholas Cruz a little bit, the Parkland shooter.
Oh, yeah. Yeah, the cameras inside the house caught everything. That's what I thought was hilarious. Because the cameras watched her... House. Yeah, it was their own security cameras. And you know what the scariest thing about that security footage was? The younger sister's playroom. It looked like a fucking tornado gone through it, I swear to God. If my daughter left her room like that, I'd be so mad. Also taunted everyone making a post online saying, have you seen Tristan? Oh yeah, the day that he was... So the day after she was reported missing, he was arrested, put in the back of a car. For some reason, he still had his mobile phone in the back of the police car. And so he uploaded, like, videos to Facebook and TikTok and that sort of thing. Yo, has anyone seen Tristan, which was the name of the girl that was murdered? And, yeah, he's just messed up, honestly.
It's a really sad case. I mean, she was 13, I believe, when she died. I mean, she still had braces. You know, she was this little girl. Very, very sad. I should read a little more on this case before I speak about it at all. You seem to know a lot more than I do, but I'm glad he grew a conscience. At least, you know, I hope that helps the family get closure. It's not going to bring their daughter back, but it's, you know, it's better, at least, for the family.
Gwyneth Paltrow is being sued? I did not know this.
Oh, I heard something about that. Yeah, that's more controversial than Christians in a day.
Case. Live coverage beginning this week after jury selection, only on Court TV. When what's happening...
Court TV actually do civil cases as well. Interesting. Did not know that.
I didn't either. Wait, he stabbed her 114 times?
Yeah.
Wow.
It's
that is some
messed
serious rage. That is some intense rage. Young men in America have a problem. Holy fuck.
Well, I mean...
I can say fuck, right? We're at the 3-hour mark?
Yeah, I couldn't care less what you say. So long as it's not within the first 8 seconds, I'm fine with it.
Okay, good. I might have done that once, and if I did, I'm so sorry. But I'm
That's
glad I'm learning. I'm happy to be here.
Been emasculated. Oh, definitely bad parenting was involved in that. Okay.
I'm Michael Ayala here with Judge Ashley Wilcott. We're bringing you a motion hearing for Aiden Fucci. He's now 16, but at the age of 14, he committed a very heinous crime, stabbing a schoolmate, Tristan Bailey, 114 times. He pled guilty to that. He's facing 40 years to life, and tomorrow is the sentencing. But right now, we're in a motions hearing.
That's right, and these motions were filed by the defense to keep certain evidence out. And I think one of the things I really just need to point out is the fact, and you mentioned it, he is being sentenced as an adult. However, and tried as an adult because of the egregiousness of what he's now pled to, the stabbing death. But he is a juvenile, he's 16. So do they consider school records, for instance, and prior bad acts in school records? Well, he's only 16, so he's not going to necessarily have the same kind of criminal history that an adult might. So they have to weigh all of that.
And even though he is being tried as an adult, just how much does a judge take into account the fact that he was 14 when he committed the crime?
That's
very young.
Yeah.
Very young. And I think that has to be a consideration.
I think it is a consideration, but which way, right? He was 14, maybe he didn't know, or the other hand of that's pretty egregious crime for a 14-year-old to commit. What does that mean? All right, we want to get you right back into court. You're not missing any of the arguments. Let's go back to where we left off.
Limitation, I have not spoken to him. He makes no diagnosis because he did not speak to him. But that is not the end. Just because Ms. Peoples chose, as she says in paragraph 3, the defense has discretion on how to present sentencing mitigation. Sure. And they chose initially not to present mental health mitigation, or traditionally what would be considered mental health mitigation. That doesn't mean it ties our hands in a juvenile sentencing under Miller-Graham and the Florida statutes that were developed after Miller-Graham. It's very clear that Florida legislature made mental health an issue with juveniles, emotional health, maturity health, intellectual. And Rule 3.781, I believe, B.
Oh yeah, she fell over on the knife over and over and over again.
3.781B allows both sides to present equally evidence on these factors. So we are not in, you know, I keep going back to, because it's just how she keeps framing it, we are not under the death penalty statutes where the state is limited by 16 aggravated factors, none of which have to do with mental health. They're very specific. We have to stay over here unless and until something is triggered by the defense. That's not where we are. We are under 921, 1401, where mental health is very clearly, and all the other psychological issues within those
They weren't
factors
in a relationship.
is put at issue.
She was a friend. He already had another girlfriend.
And the rules state that both sides will have equal opportunity to present evidence on those issues.
Well, there goes the incel
So this is
theory.
very, very different. Just because he's not made a face-to-face evaluation doesn't mean he doesn't have enough information to make a psychological opinion. And he made one where he felt like he could. And again, like I said, he testified that he had enough in this case, and this is not
I'm pretty
uncommon.
sure the father's one of the ones
course
that's on
he would
camera
prefer
with the genes.
to evaluate him. We deposed Dr. Bloomfield an hour or two ago. Her expert said he asked to go see him.
They've precluded
He wasn't
death
allowed.
penalty. If he was over 18,
He
would be
prefers
facing
as
death
well.
penalty.
But Dr. Bloomfield, the defense's expert, had enough information to make his own opinions on a couple of the factors to rebut Dr. Pritchard. So I don't see how she can stand up here and say that no expert can do this without a face-to-face eval when her own expert opined on some of these factors because he had enough there. There are numerous teachers, deans, students, friends, family. There is a volume of information on Mr. Fucci. Would it be better or best if we were able to evaluate him? Of course, we would have loved to be able to evaluate him, but she didn't allow that, and that's fine. But that doesn't cut off the state's hands and tie our hands from being able to present evidence that's relevant to these factors if there's something for the expert or anyone to opine on. The state, you know, there's teachers, there's lay people that have opinions on these issues that may or may not call for an expert opinion. It would be no different if we were calling all of them in. If it's relevant and material to a fact for the courts to consider it, then it should be allowed. Otherwise, I'm not sure what the court's going to consider, other than the nature and circumstances of the offense. If you look at those factors, there's the nature and circumstances of the offense, the effect on the victim's family, and the other 8 all have to do with Mr. Fucci and who he is. And if the state's hands are tied, that's not the intent of the statute. That offers Your Honor not a lot of information in order to make your decision. That the legislature is very clear, because our Supreme Court has said juveniles are different. So therefore, you have to do an individualized sentencing. So for all of those reasons, Your Honor, we believe that so long as Dr. Pritchard is relying on information he was provided, can make it relevant and material to a factor in the statute, then it's clearly admissible, and Ms. Peoples can choose to do the same or not in her case or in her presentation.
All right, thank you. Ms. Peoples?
Thank you. Your Honor, the state is correct. This is not an issue of Pritchard testifying at a competency hearing or a death penalty matter, and I did not cite to either of those. What I did cite is to 921.1401, and what is the reliance of Dr. Pritchard? Not a mental health evaluation, not mental health citations, but he's relying on depositions and crime scene reports. Now, as the state is correct, we did depose Dr. Bloomfield today, and as I cited in subsection 3, he's only listed for rebuttal of Dr. Pritchard if needed. Bloomfield does not have an opinion because Bloomfield did not evaluate my client, but Bloomfield does have a rebuttal to Dr. Pritchard. And I have to clarify that. I don't want the court to think that Bloomfield has reached some sort of opinions regarding the client. He's in rebuttal. So what the state is seeking to do is to have Dr. Pritchard testify in absence of, because psychology is a science, meeting their own standard in terms of what they would use to provide an opinion. His report is 19 pages, and it's a little disingenuous to say he doesn't have an opinion regarding Aiden Fucci, where he does. In that opinion.
All right, we're going to finish up those arguments in just a little bit and have the judge's decision for you as well. But first, I do want to take this opportunity to bring in our guests with us, criminal defense attorneys, Jack Rice and Josh Schiffer, our dynamic duo.
Yes, our dynamic duo. Tell us what you think, because now we want to focus on this second motion in limine, the psychologist that the state had who's going to testify, and the defense is saying, no, he did not assess the defendant, nor did he rely on any mental health diagnoses or evaluations, because there are none. Josh, do you think this should be allowed in?
No. If so, it should be let in with extraordinary limitations. It is inappropriate in my mind for any real weight or veracity to be attached to a stand away inspection and diagnosis. It's a diagnosis on the fly. It's like a drive-by. There are actually rules in different medical professions about not doing diagnostic work unless you've had an opportunity to examine the patient. Now, obviously, there are huge exceptions to that, and evaluations and diagnoses happen based on the records all the time. But given the age, given the seriousness of what's going on, I would be very, very discouraged if the judge relied heavily on this report.
Jack, I got to ask you, because what I love is the way the defense is arguing it. They're saying by allowing him to do that, you're turning him into a crime scene expert. You're turning him to an autopsy medical expert. And I love those arguments. Let's get your thoughts on this issue.
I completely agree with you, Michael. And you add this additional piece.
We're talking about two very accomplished litigators, two very accomplished
very
advocates.
quirky people
But if you really
on
listen to what they're saying, did you hear how personal it got? They both used the term disingenuous. In other words, what they're saying is, she's lying. No, 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 she's lying. They are going after each other. You can hear the emotion in their voices, and it matters, especially this prosecutor is aggressively going after the defense, and I understand it. The defense is doing exactly the same. These are highly trained, highly capable professionals. It's fun to watch right now.
Yeah, it is, because you can tell they are passionate about their arguments. And I think a really good point that Michael and I were discussing and he mentioned and we talked about is, well, there's no diagnosis of this defendant, Aiden Fucci, in this case. And I think that's purposeful, right? I think there's a reason that no one's gone down that road. So we know the judge is not going to have that during sentencing. All right, gentlemen, stay with us. Coming up next, actress Gwyneth Paltrow is set to appear in court tomorrow in Utah.
Statements as friends and family try to get closure.
The sentencing of Aiden Fucci. Coverage begins Tuesday morning at 8/7 Central on Court TV.
It's Benny Politan. Okay, quick poll.
When what's happening in the world hits home.
What strikes me is how many children are here.
And when reporting the news matters the most. Scripps News reports. Weeknights at 8/7 Central, only on Scripps News. Sunday nights, see the world through the real stories of real people.
It's a monetized, violent system.
We've got to do something.
In real life. Sunday nights at 8:30, 7:30 Central, only on Scripps News.
This is my commentary. I have some unique commentary on all of the ads. This helps us avoid a copyright strike. Hayden, please come help us. Oh my God, what am I going to do? Ah! I know about copyright law to the extent that it covers film.
Gwyneth Paltrow, the Hollywood actress, being sued for a ski collision.
This is a he said, she said on the slopes.
The injured skier claims Paltrow ran into him, causing serious physical harm.
I'd like to be vindicated. She denies the allegations and is countersuing for $1. Now, a jury will decide, and Court TV will bring it all to you.
The Gwyneth Paltrow ski crash case. Live coverage beginning this week, only on Court TV.
Okay, Gwyneth Paltrow ski crash case. Anybody have any information?
Welcome back. Michael Ayala here with Judge Ashley Wilcott. Now, we did hit the pause button on the Fucci hearing. You're not going to miss a thing. We're going to get back to that in just a few moments.
And opening statements at our next live trial begin tomorrow, so we want to talk about this big civil trial for the actress Gwyneth Paltrow.
Now, she's actually the plaintiff is a Salt Lake City resident, Terry Sanderson. He's a doctor, and he's suing the actress for negligence after the two collided on the slope skiing in Utah. Paltrow is countersuing him for negligence. Each side blames the other for the crash. Joining us now is Court TV legal correspondent Julia Janae. She is outside that courthouse, been there this morning for the whole thing. All right, Julia, the jurors were actually picked last week. You reported a little bit on that. So what do we know about the jury?
The jury was picked on Friday. They had the day off today. They'll be here tomorrow for opening statements. The attorneys inside, we're talking today. No mention of settling. Things are going forward at this point. This jury is a panel of 10. There are 8 of them who are going to deliberate. 2 are alternates. And they also were sworn in an interesting way via WebEx. It was like a Zoom conference style where these jurors were at home. First time I've ever seen jury selection happen with the jury at home. But 2 things I noticed about this jury, other than the fact that they were a mix of ages and gender, but there was one woman who didn't raise her hand when the entire panel was asked if they were familiar with actress Gwyneth Paltrow. She was a woman in her 20s, appeared to be, and she is on the actual panel for this case. And I also noticed a woman who appeared to be at work in scrubs, in a medical mask and cap. Seemed like she might be in the medical field, which will be important in a case where medical injuries, especially those of Terry Sanderson, are going to be at issue.
What a great point to raise, the medical issues, because we know he is claiming he had a TBI, 4 broken ribs, as a result of the ski accident. All right, and those are the kinds of things that I would think we might hear during the opening statements by each side. What do you know, Julia, about what we might expect?
None of that makes sense. How do you
We
have
can
a
expect
traumatic
to hear
brain injury when your
two
ribs are
different
broken?
versions of the exact same scenario, and really the only difference is going to be the positioning of
God
these
damn it,
two
I'm doing
people.
the
Gwyneth
best that I
Paltrow and
can.
Terry Sanderson both claim that they were the downhill skier, and they should have had the right of way from the other person who they say slammed into them. We know that Stephen Owens, the attorney for Gwyneth Paltrow, is going to be delivering the openings for her side.
I'm going to send
Lawrence
me a
Bueller
link,
is going to be
so-
the attorney presenting for the plaintiff in this case, Terry Sanderson. And in the gallery, we
hope Hayden
expect
is
that Brad
okay.
Fulchik, who's the husband, writer-producer husband of Paltrow, will also be there. Her children
So
may
I'm
be
watching
testifying as well
Gwyneth
and
Paltrow,
coming to this trial because they
you know,
were all on a
being an
family
almond mom.
vacation when this collision happened. So
Kissing
though
some
they
guy.
didn't see the impact, they were there to talk about what happened immediately after.
It's all very
Yeah, no
interesting.
doubt, Julia. This is a classic he said, she said situation.
Classic, absolutely.
And quite frankly, who's lowest on the hill can really, it's not that simple. You would think it'd be simple, but the way slopes work, people coming from different directions, it really could be difficult to figure out. So the question I have for you is, do we expect Paltrow to testify?
Oh, this guy's a good question. Yeah.
We do expect
Am
her
I
to
too soft? Am I
testify,
too loud?
to take the
Tell me.
stand in her own defense. And this isn't the first time that she's had to take the stand in a trial. Back in 2016, she had to testify in a criminal trial. A man was accused of stalking her. It was the second time that she had taken him to court, or rather prosecutors took him to court for stalking her over the course of over a decade between. But someone who is not afraid to testify. And actually,
everybody.
one of our legal analysts, Philip Dubé, last week, I want to resurrect something that he said
Jeff
about
is
being
sleeping.
in
I
the
can't
courtroom
call him
when
in
she
right now.
testified in California.
Okay, everybody go to
I
my YouTube
happened
channel.
to have been at the courthouse
Remy,
when she testified as a
R-E-M-Y
victim in a stalking
_,
case. It was out
legal.
here in LA, and I
Follow
caught a
me.
glimpse of her.
I don't know. Is Hayden alive? Did he? What happened to Hayden?
back.
Did he hit his head? Oh, that was disastrous. Thank you so much for coming back. There were a lot of ads. Everybody was telling me to do stuff. I have no idea. I'm lost.
Sorry, guys. Chandler unfortunately doesn't have admin privileges on the channel, so she couldn't
I
do
don't-
shit all. I legitimately thought they were going to be going longer than that, and I thought I had time to get the daughter ready for daycare. So my sincere apologies.
I'm perfectly okay with it. Thank you. That was an entertaining little excursion. I guess so. I guess I was in charge for a moment there. You know, it was a.
They legitimately made it sound like they were going to go back to the motions. So I don't know.
I thought they would.
sure.
Apparently they didn't. Yikes. But thank
Oh,
you,
well.
everybody. Thank you, chat, for hanging in there with me. I appreciate everybody sticking together. Let's move on to the next thing. Thank you so much for coming back, Hayden. I really appreciate it.
Sorry about that. There was a minor emergency as well, so I was going a little bit.
Don't
longer than I
worry about it.
intended
It's
as well.
totally fine. I'm completely okay. I'm not suffering or struggling or anything like that.
Oh shit. Okay.
It's a good hazing
About 40 plus
experience,
viewers
though.
though. That's fine, people. Because unfortunately, Tweety, occasionally real life does get in the way. So I'm sorry, very sorry. Shit happens.
I did do
I
some
was not
commentary. I did some commentary to try and keep us from getting copyright strikes. I know about copyright law to the extent that it applies to film and music, but I'm still learning some things. And stop asking about my feet, please. I'm not showing my feet. Stop that. I'm not. It's not happening. They're very cute. They're lovely. You're not going to see them. Bye.
No. I had to get the daughter ready for daycare, so I had to get her dressed, had to get the bag packed, make sure that she was ready for the pickup. Okay, so we're all good now. Someone else is blowing up. Okay, all right.
They're painted. What do you want to know?
Oh, good God. Okay. All right. Let's exit out of that. All right. Let's actually... I'm sick of Laura crime. Sorry, it's Court TV. Pains in the asses. And yes, people, as I said, I'm legitimately sorry. We're going to do what I said we would. All right.
I've instructed my deputies to take note of anyone who has any sort of audible reaction to any the verdicts, and they will be taken into custody, and there will be an immediate contempt hearing. So we will have silence during the verdicts and after the reading of the verdicts. I hope that's clear to everyone.
There you go. You got a super chat. This is for Chandler. Uncertain about you at first, but you've grown on me and I'm going to miss you. Hope you stay in our family and we'll see you again. There you go. You got supporters.
Thank you, Sarah. I'm not going anywhere. I appreciate that super chat. I'm very happy that I've grown on you. It's a lovely thing to say.
Oh yes, we know this from the Anderson trial. I was missing in action, so people just assumed I was dead. Oh yeah, hang on, sorry for anyone that isn't aware. This is the sentencing hearing for, sorry, not sentencing, this is the jury verdict for the XXX Tentacion trial. So this is the rapper that was killed, and these are the three guys that, well, three of the four guys that were accused of his murder. Fourth guy flipped on them, gave testimony against them. He's currently, well, I mean, he'll be sentenced probably at the same time these guys are actually. But he's facing second degree, whereas these guys are all facing first degree and armed robbery. So... Oh yes, I forgot all about that. They posted videos on Facebook with them with the money just going, you know, just fanning it out and going, look at all this. And it's just like,
oh, that's not a good look.
Nope. Don't be a dumbass and post your crimes on. Did the uncle testify? Yes, he did. Gave very, very little in the way of useful testimony for anybody, really. Just made himself look bad. So that's Bowtie, Dedrick Williams, who may or may not have been driving the car. Oh, crap.
Looks like a very pleasant young
I am
man.
still here, the daughter just walked in the room. Just give me a second.
They're ready. Bring them out.
You know, it's really hard to have a 4-year-old. Have a lot of respect for him. I'm not smiling during murder trial. I'm not smiling.
Jurors are entering.
She's adorable, but she comes in at the worst possible times, I swear to God.
Well, she's little. She can help it.
Parties may be seated. Court will come to order. The parties are present. The jurors are present. Ladies and gentlemen of the jury, have you in fact reached verdicts in this case? All right. If you'd hand the verdict forms to the deputy.
No, it's not a capital case. Yep.
All right, the verdicts appear to be in proper form. I will publish. In the Circuit Court of the 17th Judicial Circuit in and for Broward County, Florida, the state of Florida versus Dietrich Williams, verdict count 1. We, the jury, find as follows: as to the defendant Dietrich Williams in this case, the defendant is guilty of murder in the first degree as charged in the indictment. Count 2. We, the jury, find as follows: as to the defendant Dietrich Williams in this case, the defendant is guilty of armed robbery as charged in the indictment.
Florida. It's in Florida, Wendy.
Count 1. We, the jury, find as follows: as to the defendant Michael Boatwright in this case, the defendant is guilty of murder in the first degree as charged in the indictment. During the course of the crime committed, did the defendant Michael Boatwright actually possess a firearm? Yes. During the course of the crime committed, did the defendant Michael Boatwright actually discharge a firearm? Yes. During the course of the crime committed, did the defendant Michael Boatwright actually inflict death to Jase Onfroy as a result of discharging a firearm in his possession? Yes. Count 2. We, the jury, find as follows: as to the defendant Michael Boatwright in this case, the defendant is guilty of armed robbery as charged in the indictment. During the course of the crime committed, did the defendant Michael Boatwright actually possess a firearm? Yes. During the course of the crime committed, did the defendant Michael Boatwright actually discharge a firearm? Yes. During the course of the crime committed, did the defendant Michael Boatwright actually inflict death to Jase Onfroy as a result of discharging a firearm in his possession? Yes.
He looked so good in that mock neck.
Verdict, count 1. We, the jury, find as follows: as to the defendant Trayvon Newsom in this case, the defendant is guilty of murder in the first degree as charged in the indictment. During the course of the crime committed, did the defendant Trayvon Newsom actually possess a firearm? Yes. Count 2. We, the jury, find as follows: as to the defendant Trayvon Newsom in this case, the defendant is guilty of armed robbery as charged in the indictment. During the course of the crime committed, did the defendant Trayvon Newsom actually possess a firearm? Yes. So say we all, this 20th day of March 2023 at Fort Lauderdale, Broward County, Florida, signed by the foreperson.
Wait, did you say the 28th?
You decide which wish the jurors poll.
Yes, sir. Yes, Your Honor. Yes, sir.
Madam Clerk, you'll poll the jury.
Yes. Juror 1, are these your verdicts?
Yes.
Juror 5, are these your verdicts?
Yes.
Juror 8, are these your verdicts?
Yes.
Juror 10, are these your verdicts?
Yes.
Juror 12, are these your verdicts?
Yes.
Juror 3, are these your verdicts?
Yes.
Juror 4, are these your verdicts?
Yes.
Juror 7, are these your verdicts?
Yes.
Juror 6, are these your verdicts?
Yes.
Juror 9, are these your verdicts?
Yes.
Juror 2, are these your verdicts?
Yes.
And Juror 11, are these your verdicts?
Yes.
Thank you.
Ladies and gentlemen, I want to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges that are enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We've recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you're also at liberty to refuse to speak with anyone. A request may come from those who are simply curious or from those who might seek to find fault with you. It will be up to you to decide whether or not to preserve your privacy as jurors. And with that said, on behalf of the 17th Circuit, in the state of Florida, all the parties. Again, I want to thank you for your time and attention and the sacrifice you made in being with us these many days. I know you heard at the beginning of the jury selection and when I excused many of the other potential jurors how serious I take jury service and how important it really is. Short of service in our armed forces, there is no higher call for citizen work than to come in and give your time and to become the judges of the facts. So again, it is with my deep appreciation for your time and sacrifice in being with us. I do have for you these certificates of appreciation suitable for framing, they tell me. I don't know that anyone actually frames these. However, you might want to hang on to these certificates for at least 12 months. If you get called in for jury service in the next 12 months, these certificates will show that you've fulfilled your civic obligation and are exempted from jury service for 12 whole months. 12 months and 1 day, they're not going to work anymore, and we'll be happy to have you back. But in any event, again, I do want to thank you for your time and attention. I'm going to present you with these, and with that, you will be free to go.
After this trial, I can't say I'm shocked. That's a prosecutor. She was absolutely killer in this case, I'm not going to lie. She took no crap and took no prisoners. And there's Mummy Esquire.
I wonder if those are knockoff Chanel earrings or if they're really Chanel.
She was killer, but looks like the bad kind of low-budget sci-fi film. I can kind of see that. Okay, so apparently even in handcuffs, Mr. Smug's still sitting there with his smirk on his face. I'm guessing maybe he's just got resting smirk face, people. I genuinely thought that'd be gone once he was in the cuffs.
I just said I missed this one. It seemed eventful, maybe.
Sorry?
I said I'm kind of sad I missed this one. It seemed eventful, maybe.
Oh, the trial itself was bloody eventful, but it was painful to watch because of the court audio. I'm not sure at what point they fixed it, but I will be going back and rewatching the days that I missed. You're welcome to join if you want, but the court audio was horrible. Honestly, I am not going to lie.
That seems to be a consistent issue. I'm always interested. I always like watching trials.
Fair enough.
I'm a little bit of a trial junkie. I can't really help it.
That's right.
All right, parties may be seated. Court will come to order. Any of the defense requesting PSIs?
Not on behalf of Mr. Newsom, Your Honor.
Go ahead.
No, Judge.
Let me see counsel for a second.
it appears Hayden's left again. Pray for me that he comes back soon. Oh. Guess I am just barely holding down the fort. I'm not really doing anything. All right, so we have some people here. They're in a courtroom. Some stuff just happened. The judge was talking about things. There's the defense. There's the prosecution. Seems to be a criminal trial. I think there were some murder charges. And somebody I think was just convicted of something, possibly, although I'm not entirely sure because I was not following this. So you got that guy, and he looks pretty smug. And then you got that other guy, and he's very debonair. And then you got that other guy. I don't know if he has anything to do with the charges, but you got some bailiffs. Tell me if my commentary is meaningful or helpful or entertaining. No? No. I guess not. Hard-hitting analysis. Why, thank you. I really appreciate that. How's my life going? My life's going pretty well. I'd say I'm pretty happy to be here. What else? What else? I'm looking through chats. People are entertained. Oh, I'm happy to hear that people are entertained. You gotta talk more like a Mexican soccer announcer. I don't really know if I know how to do that. I appreciate the commentary and the suggestions. So it looks like these guys, they all kind of feel some kind of way about what just happened in the courtroom. And they're thinking about what they did and what led them to being in the position that they're in. And the bailiffs, well, you know, they're hanging out, they're doing what bailiffs do. Chandler, you're doing great. I've enjoyed having you on this trial. Oh, I'm so happy to hear that. Because you asked, this is Sebastian, and he's very cuddly. He's been sitting next to me this entire time. So Illegal Vices, my name is Brandon, so I'm gonna have to read out super chats. Kind of
Damn it.
I had to take a call. Is Chandler drunk yet? I don't know. What do you guys think? Do you think I'm drunk yet? I don't think I'm drunk. Nah. And maybe a little tipsy. It is 2 p.m. in Los Angeles, California, and I'm having a really good time. I'm very happy to be here.
Oh, there you go. Oh, God. Where are we? Oh, you're already at 321 subs. Congratulations.
Who, me?
Apparently.
Wait, really? Oh my god, that's amazing. Thank you, guys. That's incredible. I didn't even put up a video.
Oh, you probably pull a Rob and get to your 1,000 subs and 4,000. Well, I mean, you can't get to the 4,000 watch hours without a video. But yes, Andrew, we're aware that there is no court sound. They have
yeah, because they turned the sound off. What do you want us to do, really?
Johannes wants to know how your studies are going. You were prepping for the LSATs, weren't you?
Yes, I am prepping for the LSAT. I'm enjoying it. It's definitely... I've been spending less hours on it than I had intended because, well, the Anderson trial took up a lot more time than I expected it to, but I think I'm making some progress, and I've been doing a lot of logic games work, so going well. Thanks for asking.
What the hell is an AMA? I should know that.
It's like a Reddit thing. Ask me anything. I don't know if I'd answer any question from anybody, but I would answer some questions.
Go until we have some sort of audio here. Forgot that we weren't live. Court is as far as it goes.
Mr. Newsom, rise. Trayvon Newsom, a jury of your peers having found you guilty of the crime of murder in the first degree, this court now finds and adjudges you to be guilty. A jury of your peers having found you guilty of the crime of armed robbery, this court now finds and adjudges you to be guilty. I will set your sentencing for 1:30 on Thursday, April 6th. Michael Boatwright, rise. A jury of your peers having found you guilty of the crime of murder in the first degree, this court now finds and adjudges you to be guilty. A jury of your peers having found you guilty of the crime of armed robbery, this court will now find and adjudge you to be guilty. I will set your sentencing for Thursday, April 6th at 1:30. Also, you will appear Thursday, April 6th at 11 to deal with your probation violation cases.
Of course he was on probation.
Dedrick Williams, rise. Dedrick Williams, a jury of your peers having found you guilty of the crime of murder in the first degree, this court now finds and adjudges you to be guilty. A jury of your peers having found you guilty of the crime of armed robbery, this court now finds and adjudges you to be guilty. I will set your sentencing Thursday, April 6th at 1:30. I think he also has a probation case. If you're here at 11, we'll deal with it at 11. Otherwise, we'll deal with it at 1:30.
Yes, sir.
All right. At that time, after the sentencing, you will also be advised of your appellate rights. If there's nothing further today, this court will be in recess.
So we have it, peeps. All three officially found guilty as charged of first-degree murder. In April, we will find out exactly how long they're going to go away for. Personally, I'm interested to see exactly how long Cheeseburger gets, frankly, because I think he, well, after how much testimony he gave in the trial, I think we can all agree that he probably has a limited lifespan left. So, yeah. Where are we? Do have a video that Mighty has asked me to play, and I'll be very kind to him and play that for him, just to give an update on what's coming up for him. I'm personally going to be doing a little bit of a revamp. I need to start putting out a little more content, frankly, rather than just trial streams. But we're going to see exactly where that goes, peeps. So we'll start with this. Hang on, why do I need to actually stop the screen? Of course I do. Cheeseburger did not kill himself. No, I fully expect the Cheeseburger did not kill himself. Actually, can I open this in? How can I open this? This is a YouTube video, isn't it? Oh no, I can just download it and open it that way. That works. Couldn't just send me a damn YouTube link, could you, Marty? Present, share screen, Chrome tab. Alright. So if you don't know who Marty is, he's a good guy, very good friend of the channel. He does news and stuff, has pretty much daily shows. He's been helping me out with some of the trial coverage too, which I very much appreciate. And he's got some very interesting stuff coming up, so let's have a look. As soon as I add it to the actual stream, god damn, I'm tired.
What time is it in Melbourne?
It's just gone 8 in the morning.
Mr. Gorbachev, tear down this wall.
You fucking asshole. Bet on my channel, you prick. There you go. You happy? I shared it. Alrighty, guys. So, yeah, we'll be back tomorrow. Oh, it was really loud. God damn it. I'm never going to get the hand...
I guess it was really loud.
Yeah. You know, when I use the bloody volume booster, all of a sudden it causes everything to go through as if it's... Loud music and incest, what did I miss? You missed what Mighty's covering this week, which has absolutely nothing to do with me. I just thought it'd be a mentioned share his video for him. Alright guys, we'll be back tomorrow, early morning. I'm probably not getting any sleep tonight because I'm going to have to stay up for closing arguments. So I will see you all on Jeff's stream, basically. So, as always guys, remember, you are not a piece of shit. You do have value, and you contribute to society. Even if all you do is hit that like button. Cheers guys. Oh shit, I gotta remember to turn the volume down on this so I don't blow people's ears out with the outgoing music.
Fuck this shit, I'm out. Fuck this shit, I'm out. No thanks, don't mind me. I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm out. Fuck this shit, I'm out. Fuck this shit, I'm out. No thanks, don't mind me. I'ma just grab